Nice.
You know.
Nice.
The guy out west sent this to me, and it's I can forward this. Well, I don't know. I'll send you the whole group.
Put it on the group, yeah.
Yeah.
Yeah, I've got that. I've got that email. I was watching it last night.
Yeah. The old dog new tricks. That one.
I can't remember, but
yeah. This one runs about 41 minutes.
Right. It was. Yeah.
Yeah. So that's good. Matter of fact, you got the the Constitution identifies if you get a benefit in one state, it applies to the other states. So now that's a defense.
Oh.
Right. Right. As long as the state's taking federal money, it
Well,
applies.
okay. Okay. Yeah.
That's how California's shipping marijuana all over the place. One of their statute. And they got a legal defense.
It's just a matter of time before everybody has to will legalize it. I think New Jersey just
What's that?
medical.
Yeah.
Oh,
They
yeah.
changed the name to medical marijuana. Not all of a
Yeah,
sudden
no,
makes it
I
okay.
get the towns.
Just by changing the name.
Well, it would have been nice to have the cover when I was
Yeah.
smoking it anyway. Back when.
We'll do the land patents,
Anymore, though.
and we'll see where that takes us. We'll get the how to disappear today.
And that concludes
Come on
today's
in.
meeting.
No, I don't have it in this. I get it. When I pull up my email on my laptop, it shows up. This one here for some reason it doesn't really. Anyway.
My laptop downloads the email, so it's no longer available on the phone. If the phone sees it first, it gets it, but the laptop clears it from the
So the
server.
Portugal 10. That one. At Yahoo.
What's your email? I was going to
Yeah,
send you the NSEA form so you can search for
Portugal 10.
That's Portugal 10? Something like that. Yep. Here's your bacon.
Send it to me for one.
This is
G-R-O-U-P.
what I could do.
One.
This is all because of you.
Number one.
If it wasn't for you, I wouldn't be
USA.
here.
Well, not for you. You would
So my wife thanks you too.
My dad told me if he hadn't had children, neither did I.
couple, right? Still a couple.
Yeah, could be.
My dad
We're
told me
over.
if
We're just
he
going to go.
hadn't
No,
had
we want to
children,
close.
if he hadn't had
We're going to
children,
go ahead and move ahead anyways, and when they show up, they show up. Go for it.
I'm gonna attend.
Okay, well, that's fine.
Yeah. I need my sermon this morning. Might as well come to Glenn's sermon.
I'm an equal opportunity sermoner.
Yeah. Or summoner.
Are you going to pass the plate at this Sunday?
It is Sunday, but I don't pass the plate. But anybody who wants to make donations, I'll take them. You know, it's all information that you can easily find online. This is about land patents, and then maybe depending on how it goes, we'll do how to disappear, and maybe the intervention or void judgment today. We'll see how it gets us, where it gets us. So we're all products of the government's educational system, and the government has taught us what we need to know to operate in their system, but have they taught us everything? Did you pay for your land with Federal Reserve notes or their equivalent? And that's one of the big hooks they have in us, is this fake money they have circulating around, because really, can the bail presume in the so-called courts that you use Federal Reserve notes or their equivalent? Because all they are is IOUs. Mm-hmm. Was the payment shown on the deed? Was it an S with one vertical bar or two vertical bars? There's a font called Garamond that has, if you do size 14 or bigger, it's got two vertical bars. So I'm very particular about normally most of them are just one vertical bar, and that's like pesos, right? That's fake money. Matter of fact, from what my research has shown is that the S with 2 vertical bars originally meant for US, and at the bottom of the U cut off, basically.
I thought it stood for unit of silver.
Well, it could be.
Yeah.
I mean, that's entirely possible.
It goes back to the thaler, the Dutch thaler. That's what it does, and then it was, anglicized as dollar. And the dollar literally has the ridges on the edge. That was the reason why they used that, because that's a security device. You could see if it was shaved, whereas the other coins weren't struck that way.
Ah, that's very interesting.
That's what it is.
I've always wondered what that was. So you can tell if they're, if it's been
It's a
shaved.
security device.
Right.
Because it's knurled, or struck that way.
Right.
It's struck in a die rather than knurled today, but that was a security device. So you could tell if the bank had got up in the middle of the night and shaved.
Not the bank, it was a lot of merchants would do it.
Well, that's
They would-
true.
They would
Right.
take coins, they would send off a little bit or pile off a little bit
Right.
of each one and pass them on, and then the next merchant would do the same thing. And they wear down pretty quick. And taking a little bit off each one, you start piling up some gold and silver.
Yeah.
Right.
Yeah, it's THALLER.
Ah, is that right? Well, that's good to know. Maybe I should make another video about money. But anyways, do you have a mortgage, or did you have a mortgage? Only a U.S. citizen can access bankster debt. Can the bail priests and the so-called courts presume you're a U.S. citizen? Come in. That's all. Dave's not here. You've heard that thing with Cheech and Chong, right? That little thing about Dave's not here? That little, you ever heard that one, the Cheech and Chong?
Yeah, we talked about it yesterday morning.
Yeah, we did, dear.
That question, did you have a mortgage? Does this mean that you have one in the past, or you
Well,
at the time that the patent was
when you
done?
have one in the past, even,
You still have it.
it really never goes away.
Yeah.
But you
It
have
clouds
to,
the title.
but you can, it does, but you can defeat that, but you have to do some extra things.
Well, okay,
See what I'm saying?
yeah,
Yeah, you don't want to get a mortgage or even a line of credit,
right.
anything that encumbers that or, does something to it. That's why when I buy land, what I do is I manage some trusts and some limited liability company, a couple limited liability companies. So I'll have them deed it in the name of the trust or limited liability company, and then I'll have the partners in the limited liability company sign a deed to me, and what I do is I prepare that deed,
Right.
so it's got all the wording that I want. You see what I'm saying?
Yeah, I've done that too.
And I send it to them, and they sign it, send it to me. And so,
If you get them to sign it first.
oh yeah, I have no trouble with that.
Yeah.
So these are actually, might as well circulate these around. You guys can have a chance to look at them. These are some holdings.
Yeah.
This one here is one where they were very interested in what I was doing, and so they were more than willing to use my terminologies and wording and stuff like that. And they actually had another piece of property later that they sold that they wanted to sell to me, and I didn't have the money at the time. But so this is one that where they actually used the wording I requested and everything, and I was talking to them about the land and all that. And so it didn't take long. I just kind of made a few comments when I was communicating with them, and I could tell they were really interested. So I take the opportunity to educate people. So anyways, this is, I'm not sure if the land patent for this one was here. Let's see. This one? Oh, it it is. Yeah. So here's the land patent that I attached it and incorporated into it. They have these railroad land patents where they granted huge tracts of land to the railroads to finance the railroad go across. Anyways, so you're welcome to pass that around, take a look at it. So, and this one here, they've never sent me a tax notice either, by the way. Matter of fact, usually what happens...
Were the railroads tax exempt?
No. No, that's part of the illusion.
Yeah, I wasn't sure.
They sell it to a corporation because then, and the railroad gets the land patent, right? Well, when the railroad sells it to a living man or woman,
Right.
then they can only accept commercial paper. And so if you really don't know what's going on and how to do it, then the land is essentially given back to the government.
Right.
You see, because you use their IOUs to pay for the
Yeah.
land. And we're going to talk about that in here. What's the date on that?
The 12th of August, 2011.
Yeah, there we go. So this is the letter that I got that I served on the top is the letter I got from them. The second one is, no, this is the letter I sent to them. I sent it by registered mail, okay? And then the second one is the letter they sent to me. And the attachment. So it's all kind of like a package.
You're saying the county, this was done where?
This was Arizona.
Arizona?
Yeah.
To the county seat?
The county recorder.
County recorder.
Right.
What county was that?
That was Apache County.
Apache County.
Yep.
The government, they sent you a receipt too, probably, with that.
Well, they sent me a, well, take a look at it.
Yeah.
You'll see what they sent you. It's right here.
Yeah, I had a receipt that came with mine.
Well, they didn't record it.
Oh.
They put it in a special file.
Oh, they did?
Yeah,
Oh,
a special file.
okay.
That's the tax-free file.
Okay.
That's where the land patents go. I'm serious.
Yeah,
Watch it, read it.
Some of them I don't think knew what to do with them. They just recorded them.
This is the Gold Reserve Act of 1934, located at 48 Stat 337. As used in this act, the term United States means government of the United States. The term currency of the United States means currency which is legal tender in the United States and includes United States notes and Federal Reserve notes. So, if you think about it, what they're essentially saying is that Federal Reserve notes are meant for internal use of the government only, right? That's what they're for. They're not meant to be used by us. They're used for government employees only. So if you use Federal Reserve notes, you're saying you're a government employee. So if you show on the deed that you paid for the land with Federal Reserve notes, or the judge can presume it, he presumes you're a government employee. And you didn't really pay for the land.
If you put in it for in consideration, I don't think I put anything else besides that.
I always put down silver, coin.
Yeah.
And if you read my deed there, it'll say how much silver I paid for the land.
Didn't put the exchange just in consideration, I think it was.
Yeah, no, I always put silver coin.
Yeah.
I mean, otherwise you don't want to give them any room to presume anything, because they're really good at presuming
Oh, I
stuff.
know. When these land patents were first purchased, was that in silver? I wonder.
It was lawful money.
Yeah.
I mean, the land patent was issued in, oh, you got the land patent, son?
Missouri and Arkansas?
Right, yeah, so it'll be on the last page. Was issued in May of 1918. Okay, so that's before or shortly after the Federal Reserve.
Right.
That's when they were still using lawful money.
Well, this was in 1807, and that's when.
Well, that would have been lawful money too.
Yeah, that's what I'm saying. But if that's purchased in lawful money, That wouldn't change if that thing was purchased.
No, that's true, but if you put a lien on it since then that's a problem. But that's not a fatal problem,
Right.
and it's really what it comes down to is you need to go after them, sue them in federal court. That's what I would do.
Well, that's
Tell
what
them
we're
tell them that you're the descendant of the original.
Right.
You didn't sell the land, and they stole it, and you have by right of to own the land. You own the land patent. They've gone and put no trespassing signs. They went and sent the sheriffs over there, and I would file a criminal complaint. That's what I would do,
Okay.
is make up a criminal complaint against the sheriffs, whoever came to kick you off your land, and the owners, and the taxing authority that stole it, and I guarantee you, I'll bet you some shit would go down over that.
And that gets filed with the attorney, federal attorney?
U.S. attorney.
Yes,
Okay.
attorney.
Okay.
Land patents weren't really purchased, I don't think.
Huh?
I don't think land patents were purchased.
No, they
The
weren't.
land
They were
was
granted.
granted
That's
to
Well, the land
somebody to
patent-
use.
No, they
The
were
land patent
purchased.
is evidence of the grant.
Right. And then if you don't use it properly, the BLM can actually take it back. 'Cause the
No,
land-
you're confused.
No.
BLM doesn't take anything back.
That's right.
When the government sells you the land, you get absolute title to the land.
That's right.
So what they used to do, they would have tracts of land where they needed people to go to. And if people wanted to go out there, they would get a land grant, which was land patented. And they would have to take possession, occupy, make use of it. And they had so much time to make use of it. If they didn't, they would lose it.
Those are homesteading, not patents.
No homestead, there's land patents.
No, you're confused.
Yeah.
I am?
Yes, you are.
I'll send you some stuff on it.
Well, do you mind if I do my presentation?
Yeah, go ahead, sure.
Okay, good.
Yeah, well,
Maybe the dog. We got some gloves over here, we got any?
Huh?
no, it's, I mean, I studied this back in 2010, you know.
This is as old as time itself.
I know.
Okay, a land patent is a letter's patent, is what it is.
That's right.
And it doesn't say on that land patent that there's any reservation. If you get, and you look at the land patent on here, okay? It doesn't say there's any reservations at all, okay? If there's reservations, then you really don't own it, okay?
Indian reservations?
No,
I was
reservations,
joking, it's a joke.
well, I'm not really interested in jokes right now, okay?
Yeah, but what is
A reservation is when they reserve the mineral rights or something like that. Some of them do reserve mineral rights. Some of them do reserve, like in Canada, I've seen them reserve like certain kinds of trees, different things in Canada. In Arizona, they sometimes you'll see them reserve water rights. Like I went and got some land, and it talked about water rights on the land patent. But that's it. Okay, and so then they can come and if they reserve the mineral rights, well, you still have the surface rights. Okay, so they still have to lease the land or get a lease from you, but the mineral rights were there's a thing called the law of capture where they can like oil or something like that, so then they can get your oil underneath your land, and there's not much you can do. They drill a well next to the land, especially if it's a small piece of land. But the point is that other than that, there's no reservations. They don't talk about property taxes. They don't talk about zoning requirements. They don't talk about any of that stuff. And it might be in some states, the more recent patents, if they're issuing more recent patents in some states, maybe they got reservations. But what I would suggest is you can probably go, because what happens is sometimes the government gets in possession of the land. They steal it back somehow. And so maybe back in the 1800s, somebody bought the land, and then it wound up back in the hands of the government, and now they're giving you a new patent. Well, go back to the old one.
Yeah.
That's what I would do.
Exactly.
And because really, if you think about it, the First Nations are the ones who really own the land. We're going to talk about that in here. There's court cases that even talk about it. That the government, even with the land patent, is only a color of title. And so it really isn't, it's a color of title. It's something that looks like title, acts like title, but it's not. Because possession at common law is 9/10 of the law. And so, again, a mortgage is an equitable interest. It's a fraud. And so that's why your position's so powerful, because if you could show that you had that in your family for generations, they're gonna be in a tough way. I would make a criminal complaint, and then I'd let them sit on that criminal complaint for a while, send it to the U.S. attorney, and then I would file a lawsuit, for sure. What?
In West Virginia, coal companies come in and develop the land and get all the money, but then sometimes an heir will come in and say, that was my land. The way this happened was, 1800, they sold the land in a tax sale, but they were selling it from a Paris office and from the London at the same time, so they didn't have the communication we had, and often one piece of land was sold to two different people.
Really?
Yeah, and so when the coal people come in and make all this profit from it, then a guy can prove that he had the earlier deed, then he gets all that money. But anyway, I thought it was interesting because of the communication systems, and they were selling from different offices.
Right.
Well, that was the scam that Ethan Allen did up through Vermont and New York. You check out Ethan Allen. He was selling land all over the place, multiple parties, multiple times. Oh yeah. Interesting.
So anyways, let's continue on with this presentation.
Yeah.
Under Title 12, United States Code, Section 411, it says Federal Reserve notes to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purpose of making advances to the Federal Reserve banks through the Federal Reserve agents, and as hereinafter set forth, and for no other purpose are authorized. Okay, so this is the code. Now, if you go back into the statutes, let's face it, the code is only some liar's opinion of what the statute says, and so if you can go in the statutes and prove that it says something else or something else, then the statute trumps the code. Okay, you have to understand that. But this is what the code says, and it said notes shall be obligations of the United States. In other words, it's an IOU. Okay, it's a promissory note. It's a bill of credit. Okay, the Federal Reserve notes. I think that because the United States, they set up that unconstitutional corporation in 1871, that unconstitutional corporation is what's on these Federal Reserve notes. They would never, the de jure government would never use Federal Reserve notes. Okay, and even in the Civil War area when they issued U.S. Treasury notes. Okay, well those were for that unconstitutional corporation. Okay, and so says they can be redeemed in lawful money on demand at the Treasury Department of the United States. Well, I can tell you for sure that I've taken Federal Reserve notes. I sent actually a letter to the controller of the currency, and I asked him. I said, I tried to redeem these Federal Reserve. It was complaining against the bank. And I said, I'm complaining about this bank because I went to redeem these Federal Reserve notes and they wouldn't redeem them. They didn't know what to do. And so they laughed at me. Anyways, so actually the controller of the currency sent back a letter and said, well, what did they look like? Can you send us an image? So I made a copy, put copy on it, sent it to them. And they basically, blew me off. They said that these aren't redeemed anymore. But this is this current statute. You see what I'm saying?
One idea is to send an old bill and see what they say, like from 1940s, 30s.
Right. Yeah. Well, I mean, and let's face it. I have a silver certificate, and I could send one of those, but I kind of like those. I want to keep it.
Or you could just take a picture, send it to them, and
See what
ask
they
them,
would
what
do.
about this
I'll
one?
bet if you did try to turn it in, they wouldn't take it.
Might
The
not.
problem is, legally, they're not, lawfully, they're not a valid note. A note has to conform to 5 things lawfully. The payee, the payor has to be identified, a quantity, a commodity, and time. Can't find those things on a Federal Reserve note, but I assure you, every note that you sign will have those things.
Yeah. Right. Yeah. Well, that's promissory note. Right.
Right, so you give them good paper and they make sure they give you bad paper.
Yeah. No doubt. That's the bankster thieves at
That's
work
how it
again.
works.
Yeah.
There is a distinction between a debt discharged and one paid. When discharged, the debt still exists, though divested of its character as a legal obligation during the operation of the discharge. That's these liars lay awake at night with this stuff. And so that's why when you use Federal Reserve notes, you're using a privilege. And you're taking advantage of a benefit, the benefit being of discharging your debts with limited liability.
What does that mean that the debt still exists?
Well, what do you think it means? It means, okay, sorry.
You can't pay an IOU with an IOU.
Thanks.
It means that the debt still exists. It just discharged with limited liability.
Put aside.
Put aside.
And that was the
It
benefit
means
of the
that you
bank.
can no longer seek any remedy from the courts in regards to that alleged debt.
It passes on to
See?
somebody else.
So
It's,
the person,
means the courts will no longer give you a remedy over it. The debt still exists, but the courts won't give you a
when you
remedy.
say the debt still exists,
Well, that's what the court said.
You never paid it.
So basically, when the money's created, it never disappears. It's still in the circulation, and it adds on to the debt.
Well,
So it's always there.
so then also,
Passed
if you,
on to someone else.
if you think about it,
Yeah.
if you think about it, I mean, that's what these banksters do. I mean, when you write a check, right? And whoever you write it to takes that check and deposits it in the bank, then the bank transfers them some IOUs, some fake money, electronic digits, right?
so it's
Well, the
moving debt
banksters-
around, basically.
Yeah.
The banksters take that check and it becomes part of a collateralized security obligation. You know, I don't know if you know that. They all do. All checks, all credit card transactions, everything. They're collateralizing that stuff and circulating it on Wall Street for sure. Even after it's all, you know, the actual initial transactions done, they circulate those things around and they
The way
create
I see it,
CDOs.
when you use a check or a credit card, is by doing that, they just create new money to pay off the one you're,
Exactly.
and then they keep that for them, you know.
They create
Yeah.
new debt.
Yeah.
Right.
Well, and so then they're able to think about it. They're able to securitize it. They're able to do all sorts of things. In other words, you know, most of this money that's circulating on Wall Street is fake money. You know, it doesn't exist.
So whenever we use a credit card or a check, we're helping them get richer,
Uh-huh.
you know.
Well, there's commissions, there's fees, so and there's interest. So there's always movement creates more
But when we
credit,
pay
more
with a
debt.
money order, it's just one-to-one, it's sort of direct, like silver or gold, isn't it?
Yeah. Well, but money order, yeah, that's the post office.
Right.
Okay, and that's a little bit different
Right.
because the post office actually was created before the government.
Right,
And the post office has never been bankrupt.
right.
But the United States Postal Service, I mean, there's two entities there. Anyways, so a promissory note is a written promise to pay a certain sum of money at a future time. A promissory note differs from a mere acknowledge of debt without a promise to pay, as when a debtor gives a creditor an IOU. And that's what a Federal Reserve note is an IOU, okay? Because there's no promise to pay anything on those things. The old ones, the silver certificates, actually did have a promise because it said you could go get the silver. But there's nothing on Federal Reserve notes. They're IOUs. Matter of fact, the U.S. Supreme Court even calls them forced loans, and I think I've got that court case in here. This is an act for the making of the further provision of the sale of the public lands, which was approved April 24th, 1820, and you could not use credit to buy the land. And this was in 1820 even, okay? So they had credit available then. People could use credit, bank credit.
but not to buy land.
You couldn't use it for the purchase money and the sale of any public lands. And the reason was, it's in this presentation, it was calculated to plant in the new country a population of independent, unembarrassed freeholders, that it would place in every man the power to purchase a freehold, the price of which could be cleared in 3 years, that it would cut up speculation and monopoly, and that it would prevent the accumulation of alarming debt, which experience proved never would and never could be paid. And again,
Senator King,
Yeah.
1820.
right, March 1820. This is Wallace versus Harmstead. It's kind of cut off on the bottom of the screen, but I can see it on my laptop here. We are then to regard the revolution and these acts of assembly as emanating every acre of the soil of Pennsylvania, or emancipating every acre of the soil of Pennsylvania from the grand characteristic of the feudal system. Well, guess what? It's back in the feudal system. Even as to the lands held by the proprietaries themselves, they held them as other citizens held under the Commonwealth, and that by a title purely allodial. All our lands are held immediately or immediately of the state, by the titles purged of all of the rubbish of the Dark Ages, excepting only the feudal names of things not any longer feudal. Under the Acts of Assembly I have alluded to, the state became the proprietor of all lands, but instead of giving them like a feudal lord to an enslaved tenantry, she has sold them for the best price she could get and conferred on the purchaser the same absolute estate she held herself. If you have a land patent, you have absolute title. And these have been reserved as everything else has been granted by contract.
What was the site on that?
Huh?
What was the site on that case?
Wallace versus Harmstead,
Armstead?
Supreme Court 492.
Copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. For a complete set of YouTube videos with private information, shares a DVD with over 50 searchable law dictionaries and other books and forms, contact me privately at engineerwin@yahoo.com. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept the military script, the IOUs, the Federal Reserve notes, the PayPal gifts, the checks, the money orders. Send me an email for particulars.
3. Harmstead, Harmstad.
What volume?
I don't know, actually.
Could you say that site again? Wallace vs. Homestead, what?
Wallace versus Harmstead, Harmstad.
Yeah.
Supreme Court 492, 1863. It might be by the year. Some of these books back then were by the year.
Should be able to reference the year and find the case.
Should be able to find it. There's
Yeah,
not
it'll
that
give
many
you-
cases every year.
No.
After the American Revolution, lands in this state became allodial, subject to no tenure nor to any services incident thereto. Now again, the PowerPoint presentations for these, actually there are PDF files for these, are in my Yahoo group in the files directory. And if you can't find it, I can email it to you. From what source does the title to the land derive from a government spring? In arbitrary governments, from the supreme head, be he the emperor, king, or potentate, or by whatever name he is known. In a republic, from the law making or authorizing to be made the grant or sale. In the first case, the party looks alone to his letters patent. In the second, to the law and the evidence of the acts necessary to be done under the law. To a perfection of his grant, donation, or purchase, the law alone must be the foundation from whence the authority is drawn, and there can be no other source. So, again, that's why you're in a powerful position, because you have the law.
Yeah.
And I would file a criminal complaint against those people for sure. I'll bet you'll get them removed,
We're all holding
and maybe get them some free room and board.
Got to file a criminal complaint.
I need some help. Yeah, I know. He told us about that advice.
The land patent is the muniment of title. Such title being absolute in its nature, making the sovereigns, notice they say the sovereigns, absolute freeholders on their land. So, but you cannot be truly sovereigns unless you own land. That's one of the requirements for a nation under international law, is you have to have people, land, and resources.
Right.
And so,
And no debt. That's a factor too.
that's, well, I don't have debt, but actually no sovereign really has debt. The Sestake Trust has debt, but so you can separate yourself from that easy enough, because they won't loan it to a sovereign, because they can never get it back.
Well, how could the kings that were sovereign in England borrow money from the banks?
Because they didn't.
They didn't borrow it?
They didn't. They set up corporations, and the corporations borrowed it.
Thank you.
You see what I'm saying?
Okay.
Yeah. They didn't borrow it. king is immune. They can't collect it from the king.
Gotcha.
It might have looked like they were borrowing it,
Right, I
but
mean,
that's not what
kind
was
of a
happening.
shortcut when they explained it.
Right.
The king made the arrangement.
Yeah, well, the
Okay.
corporation did it.
No, I understand now, thank you.
This is 12 Stat 292, Chapter 45, August 5th, 1861. An act to provide increased revenue from imports, to pay interest on the public debt and for other purposes. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled. Section 8. And be it further enacted that the direct tax of $20 million be and is hereby annually laid upon the United States, and the same shall be and is hereby apportioned to the states respectively in the manner following. Section 9, and be it further enacted that for the purposes of assessing the above tax and collecting the same, the President of the United States be and is hereby authorized to divide respectively the states and territories of the United States and the District of Columbia into convenient collection districts, and to nominate and by and with the advice of the Senate to appoint an assessor and a collector for each such district, who shall be freeholders and resident within the same. So
they were free.
they have to get, yeah, they were supposed to be.
They ain't anymore.
Well, they were supposed to be, and they
Yeah.
might be.
Yeah.
The people that are the tax assessor collectors, I'll bet you they don't pay any tax. I'll bet you they get a royalty on the tax they get. I'll bet you they don't pay any. I'll bet you.
The term in Congress assembled, now isn't that the de jure Congress, do they still use that terminology today, in Congress assembled?
Yes, they do. When the Southern states walked out of Congress in 1861, then really it ceased to function. It's been operating under executive authority ever since. And so this is the, even though the corporation didn't get chartered until 1871, you got to assume that this is the corporation that's operating.
But that term in Congress assembled is still used today?
Oh, yeah.
Okay.
And be it further enacted that before any such collector shall enter upon the duties of his house, he shall execute a bond for such amount as shall be prescribed by the Secretary of the Treasury, with sureties to be approved as sufficient by the Solicitor of the Treasury, containing the condition that said collector shall justly and faithfully account for to the United States and pay over, these things can be quite lengthy. And be it further enacted that the said direct tax laid by this act shall be assessed and laid on the value of all lands and lots of ground, with their improvements and dwelling houses, which several articles subject to taxation shall be enumerated and valued, with the respective assessors, at the rate of each of them is worth, in money, on the first day of April, 1862. So, again, this is all about, this is where property taxes came from, right here. This act. That's where it all started. But it's noted that it's for imports.
One thing that I noticed on the slide before is that it says freeholder and resident. So they are already converting some of them to residents. The one before that, maybe. Right there on the bottom on the right. Freeholders and resident.
Within the states, yeah, that's interesting, all right.
There was another slide previous that identified allodial and legal fee simple. And fee simple is a feudal title. They're mutually exclusive, if you were to dig in. However, land patent can only be held in the name of a sovereign, or can you put in a trust?
Under the current regime, a trust would fall under the definition of corporation under Title 15, United States Code, Section 44. And so I wouldn't, I doubt you'll ever get it off the tax rolls by having it in a name of a trust or anything but your name. I always put it in my name, and I've always been able to get it off the tax rolls. If it's in the name, I manage trusts, and so then there is land that I own that's under the name of a trust. And matter of fact, what I did, I wonder if I got it here.
I wonder if you get it off the tax rolls and then quietly quitclaim it to a trust. You know, after you establish the
Well, you could,
non-taxability
yeah.
of
I
it.
mean, there's nothing saying you have to record that kind of stuff. Just quit claim it to a
Right.
trust and put it in a
Right.
file.
Exactly.
Yeah, there's nothing stopping you from doing that.
No.
I went and I bought some land on eBay, and it turned out it was from a guy who happened to be a judge.
All right.
And he was advertising as being a quarter acre of land. When I went and looked at it, it was like one of these little teeny weeny little postage stamp lots that you barely get a mobile home on, sort of thing.
Yeah.
It wasn't even a fifth of an acre. It was much smaller than that even. Anyways, I went and so I went and contacted him, and I said, this land is not a quarter of an acre, and he refunded all my money. So I basically got it for nothing, and it was in this oh, what's the name of the county? It's in Texas. Anyways, it's like about 50 miles south
Is
of
that
Dallas.
Bowie?
No.
One in Bowie?
No, that was not Bowie. That was near Corsicana. Anyways, it was in this gated community. The community was pretty ritzy, actually. But it was in this gated community. But there was a bunch of the lots that were all forested and nobody was doing anything with, and this was one of those amongst all those. And what I did was I bought it under the name of a trust, okay? And so then what I did was I sent by registered mail, a deed transferring it from the trust to me. I sent it to the county recorder without the filing fee, okay? In Texas, they don't have a land transfer tax, okay? And so it's just a filing fee for the county recorder.
Right.
And they sent me back a letter saying that, you know, they couldn't file it because I hadn't paid the filing fee. Well, actually, there's Texas court cases that say that once the county clerk has it, it's filed regardless of whether they file stamp it or not. And so then what happened is they started putting me on their solicitors. They sent these lawyers after me for threatening tax sales and stuff like that, right? And so then, you know, that went on for like 2 or 3 years. They're sending me these solicitations about tax sales. And so I sent them back a letter recently telling them that I own this land, here's the deed, and you refuse to record it, and if I hear another word about this, I'm going to sue your butt off. And I haven't heard anything from them since. And because it's not, I told them I own the land. I'm the living man. You see what I'm saying?
Right.
And yeah, so they haven't messed with me
That's
since.
interesting.
But again, the corporation technically it falls under Title 15 United States Code, Section 44, corporation. So you have to, in my opinion, I don't think you'd be able to use it under that and get it off the tax rolls. Now I know people in Texas, but again, it's because there's a lot of people in Texas like me and Bill and a lot of other people that are fighting in our own little ways,
Right.
and so. It's a lot easier in Texas than it is a lot of other places, probably because there's more people doing it.
And you got a different mindset in Texas anyway. You know.
To some extent, you're right. People aren't as dumbed down as they are in other states.
The advantage we have in Texas is that every county, the same attorney firm handles every single county.
Oh, yeah?
Taxes.
Is that
So if we
right?
take one down, we've got the whole state.
That's interesting.
Yeah, it is.
So, yeah. Anyways,
You know,
let's.
one rat rather than many.
Yeah.
Glenn, do you know how they defined dwelling house back then? What a dwelling house was?
I don't know. Do you know?
No, but I think it had to do with commerce. But I think in a previous law, they have dwelling house as 2 separate words. So I was wondering if that made a difference.
You know, I don't know. There could be a typo in here. I basically typed it in here because,
typed it in.
you know, or
Okay.
pasted
All right,
it in
well,
and fixed the errors. You know what I mean?
Because in Ohio, the houses are single-family dwelling, and that's commercial term.
Right.
So the dwelling is a commercial term.
Okay, well that's good to know. Anyways, This one talks about how they require, they're supposed to, shall require all persons owning, possessing, or having the care and management of any lands, lots of ground, building, or dwelling houses. And so under the authority, this is, but it says all persons, okay? And they even define in other acts that a person's a fictitious entity, okay? So really this is for corporations. It really is. And so, so that's basically the reason I wanted to put this in here, because it's basically persons possessing, having care of management of any lands. You see what I'm saying? This is section 29, the Board of Assessors. Okay, we all know that there's a Board of Assessors and a Board of Equalization. Okay, and this is where all that stuff is set up. Be it further enacted that as soon as the Board of Assessors shall have completed the adjustment and equalization. Okay, so equalization and all this other stuff that they do. This is all found in this act. This is section 43, that every collector, and this is, in my opinion, what eventually became Title 18 United States Code, sections 241 and 242, where violating your rights under the color of law. Because be it further enacted that each and every collector or his deputy shall exercise or be guilty of any extortion or oppression under color of this act. And so, again, the key is to find a judge that wants to be a judge instead of a bought and paid for clerk.
Who dreamed up this plan to start taxing this way?
Sorry?
Who dreamed it up? Like why did it all of a sudden become part of the government's action?
I think that it was all planned. I think that they've been doing the same thing for centuries in other countries. And I think that the Civil War was orchestrated, and they went and planned and orchestrated the whole thing. It's divide and conquer, right? I mean, that's the whole reason why they put slavery here in the first place, is part of divide and conquer. You know, they divide you and conquer you. And so, you know, that's the whole reason that it's all coming from the Roman cult.
Right, so they had this in their files from England or wherever, and they just found a way.
I mean, look at what happened in 911. Within, 7 days, they passed a 2,000-page act, and when people asked them, well, gee, where'd you get this act from? And they, well, we had it all along.
So true.
I think in West Virginia, several courthouses have been burnt down, and then the lawyers rush in and write new deeds, and the original landowner is done.
Well, and the Civil War especially, they burned all the courthouses.
Right.
And so then, you know, when that kind of stuff happens, then you know, they can do all sorts of things.
Yeah, you rewrite the historical record.
Well, but at the land titles, you got to understand that they only keep a copy. Okay, you're supposed to have the original.
Right.
So
a lot of
someone
people are relying on the court to have it,
Well, I wouldn't.
But
you
many
know.
people do.
If you do, you're a fool.
Right. There are many fools.
Yeah, there are many fools, for sure.
You know, in Ohio, they've been taxing property since 1825. Prior to that, it was by land classification. And then in 1825, it became ad valorem. So I did some research as to what the classification was back then, and it was just for businesses.
Right.
So it went back to 1825,
It's-
so 1861.
It's still just for businesses, you know. And again, there's people I know in Texas that have. There's a lady that I know that I met recently that she had an expensive house in an expensive neighborhood, and she had been gone through a foreclosure, but she was still living in the house 10 years later, and they were sending her these tax bills, and she didn't have the money to pay for the tax bill, and so she went in there and started reading in the Riot Act, and they said, don't worry, we'll take it off the tax bill, we'll take it off the tax rolls, because they got no basis for it, okay, and under Texas laws, and I'm sure that you can find every other state, you can find the same kind of stuff. There's no doubt in my mind. It's just getting in there and looking. In Texas, in the Texas tax code, it says that things have to be rendered for taxation. And so, who rendered this property? I want to know who rendered this property. I want to have their ass in jail right now. Oh, don't worry, we'll take it off.
No refunds.
What does the term rendered mean?
Well, I mean, you're saying here, you need-
Authorize.
authorize the taxation. You see what I'm saying?
Okay, no.
Anyways. And this is talking about the commission. Okay, back when this act was passed, the collectors got a commission of 4% on the first $100,000, 1% on the second $100,000, 0.5% on everything above that. So they all get a royalty. So of course they want your property on the tax roll, but they are also bonded, they have an oath, and you can rattle their cage and all of a sudden everything will change. But the burden's on you to do that. This is homesteads. This is 1862. This is the de facto corporation again. And this is the illusion, okay? Because it's talking about persons. If you have a land patent, you don't need a homestead. Okay, so I would never do a homestead. Be it further enacted that the person, this is which was approved 1862, 12 Stat 392, to secure homesteads to actual settlers in the public domain. The person applying for this benefit of this act upon application to the register of the land in which he or she is about to make entry, make affidavit before the said register receiver that he or she is the head of the family, and the purchaser shall acquire absolute title by the purchase. Now, but it's still persons. You see what I'm saying?
Basically asking for a benefit, that's what's going on.
You're asking for a benefit, that's right. They're converting a right into a privilege. And so that's what I was, I was doing in Canada. I think that's why the Canada Border Pigs decided to pick on me, because we were getting de jure Indian chiefs, First Nations people, to grant their land, crown land, to grant a section of crown land. We were getting them to grant this land to lots of people.
Is that right?
Well, I mean, and when you read the court cases, we'll go through it and I'll show you how it trumps any crown patent any day of the week, because the crown patent is really a color of title too. It's a fraud. And the First Nations people were here first. Anyways, this is an act to secure a homestead for settlers. Okay, again, the same act. No lands acquired under such provisions of this act shall in any event be liable to the satisfaction of any debt or debts contracted prior to the issue of the patent, therefore. Okay, so see that as different. So they cannot be used to satisfy debts that you're into before the patent was issued, but after they can take it from you. You see what I'm saying? So this is basically a fake homestead sort of thing. You see what I'm saying? It's the same old stuff. A person is a fictitious entity. This is chapter 71, which is at 16 Stat 431, an act prescribing the form and the enacting and resolving clauses of acts and resolutions of Congress and the rules of construction, therefore. The word person may be extended and applied to bodies, politic, and corporate. Well, that means it is bodies, politics, and corporate. It's a fictitious entity. An act concerning construction statutes, this is New Mexico, January 2nd, 1852. The word person may be extended to bodies, politics, and corporate. That's the same wording. This is an act for the temporary government of the territory of Arizona. And at 12 Stat 664, together with all the legislative enactments of the territory of New Mexico not inconsistent with the provision of this act, are hereby extended to and continue in force in the said territory of Arizona. So rather than pass a whole bunch of acts, they said, well, all the acts because Arizona was really part of New Mexico until they split it off. And so they said all the acts in New Mexico apply until we repeal them, basically. But
That was before Arizona was a state?
Well, that was Arizona territory.
Right.
It used to be, the whole thing used to be New Mexico territory.
Right.
And they split it in half and made Arizona territory, and that's what this is.
Yeah, same with Virginia and some of
A lot of them.
Yeah, they borrow this.
This is 26 U.S.C. 7701, the definitions. When used in this title, and these liars lay awake at night making this as confusing as possible. When used in this title were not otherwise distinctly, expressly, or manifestly incompatible with the intent thereof. The word person shall be construed to mean and include an individual, trust, estate, partnership, association, company, or corporation. So those are all fictitious entities under a justum generis, right? Because there's one fictitious entity there, they're all fictitious entities. Sesticate trust. Individuals of sesticate trust. Include. So in that statute it talks about include. Well, include is limiting. That means it's only that stuff, okay? Include of the participial form thereof is defined to comprise within, to hold, to contain, enclose, comprise, comprehend, embrace, involve, okay? Include, to confine within, to hold, to contain, as the shell of a nut includes the kernel. Okay, so that's it. There's nothing else in there. The justum generis. Of the same kind or class, a canon of construction that when a general word or phrase follows a list of specifics, the general word or phrase will be interpreted to include only those items which the same type as those listed. For example, in the phrase horses, cattle, sheep, pigs, goats, or any other farm animal, the general language or any other farm animal, despite its seeming breadth, would probably be held to include only four-legged hoofed mammals typically found on farms. Thus would exclude chickens. And this, now we're getting into this international law rule adopted for areas under federal legislative jurisdiction, federalizes state civil law, including common law. The rule serves to federalize not only the statutory but the common law of a state. You know, we've heard this all before several times today or this last few days, so I'm just going to breeze through it. And then the National Mutual Insurance Company of the District of Columbia, U.S. citizens don't get an Article 3 court. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold the District of Columbia is not a state within Article 3 of the Constitution. In other words, citizens of the district and those of the states are not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union.
Glenn, you found this information and basically you typed it, and you underlined things you thought were important, but the underlining is your authorship.
Of course.
Okay.
They don't underline things in court cases.
Well,
and if I tell you, if there is some court cases they do have bold, but I'll put on their emphasis in the original. So you can assume that all this emphasis is my emphasis.
That last underlining, that really exhibits the territorial jurisdiction we were talking about.
Right. Yeah.
No, we become agents of the state. You know, where we go.
Or in charge.
Right. Well, you're a slave. You know, it's like the Canadian statute says, okay, and I can pull that statute up if you want. Maybe I will. Let's find it.
It's almost like dual citizenship. You're on the land, but still attached to where you came from, or where you acquiesced.
Canadian Ownership and Control Determination Act.
I assume, I don't know that much about Canadian law. I'm sure you got more experience in it, but I'm sure you've found a lot of parallels between Canadian law and U.S. law.
Well, it's all common law. It all comes from England. It's
Right,
the same
I
law.
understand that.
The only difference is the statutes. Okay, so common law is here. Under martial law, then only the statutes apply if you're in the corporation. Martial law only applies to the corporation. Okay.
Right.
And so under martial law, they basically override common law with statutes. Under martial law, there's no law, so they write statutes. So you have two jurisdictions. You have common law and you have martial law.
Well, how, I mean, Canada never suffered a civil war, so how did they enslave the bulk of the population?
Bankruptcy.
Through the bankruptcy?
They do it.
And the use of the money?
Yeah, it's always through bankruptcy. Thank you. Anyways, so,
See, before
there
the
it is.
Civil War, you had black and white. After the Civil War, everybody's colored.
Yeah. Well, yeah. Yeah.
That classification.
Yeah.
That's correct.
Yeah.
I know.
Yeah. Yeah, that's interesting. Anyways, so let's. Owned means subject to the regulations. Okay. Well, think about it. If owned means subject to the regulations of one act, it means subject to the regulations of all acts. You know, really, if you think about it, right? And if it means it in Canada, it's the same common law that's here as there. You see, it all comes from England, so it's the same thing. It all means it's the same basic principles of law.
Yeah, it's representative of one who owes.
Well,
You know,
yeah, I guess.
it's a debtor-creditor relationship.
Right. Yeah. So, that's what that from the current slide. If any citizen or resident of the United States does not reside in, is not found in any United States judicial district, such citizen or resident shall be treated as residing in the District of Columbia for purposes of any provision of this title to a jurisdiction of the courts and enforcement of summons. And so that started out as 26 U.S.C. 770139, and I think they moved it over to 26 U.S.C. 7408C. It's one or the other. It started out with one and ended up as the other. That's why I have both those sites there. Now, so they're basically, that's where this is codified. Originally, Congress intended that land could not be encumbered in any way. Property taxes were originated by the Act of Congress in 1861 for U.S. citizens. The Homestead Act is a privilege for U.S. citizens. State statutes are actually U.S. statutes. If you used, or the bail priests in the so-called courts can presume that you used Federal Reserve notes to pay for land, then it's really not paid for.
Can you, see, I thought when you did your research on your land, you could see if there are any back taxes owing, and then you could go in and pay those, I guess, with gold or silver. But I mean, can you clear a title by?
If you have absolute to the title, I don't.
Don't forget to subscribe to this YouTube channel. Don't forget to follow me on Steemit. And that's at Sovereignty International. Don't forget to like this video. On YouTube, don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On Steemit, don't forget to vote and make your comments. And I've also got some videos uploaded to BitChute. This is my front page of my YouTube channel. Notice the arrow is pointing at the bell, and the subscribe button's already been clicked. That's why it's checked. Normally it would be red. And when you click on that bell, that one there is not clicked because doesn't look like it's ringing. When you click on it, a pop-up comes up, and there's a box you have to check to be notified about uploads. This is Steemit. The left arrow is where you click to upvote an article. The middle arrow is how many votes it's got, and the right arrow is where you make comments. And this is Steemit again, and the arrow is pointing at Crypto Wallet. There's a hand there. When you move your mouse there and touch the profile name, this pop-up window comes down, and that's where you can follow or unfollow someone.
You were saying if we bought it by Federal Reserve notes. So we're trying to get a land patent on it, but we did buy Federal Reserve notes. So can we clear that?
Oh yeah, just transfer it.
Transfer what?
Transfer the land.
From what?
From, if you have it in your own possession,
Yeah.
what I would do, you have kids?
No, I don't have any family.
Oh. Well, I would transfer it. Do you have a close friend that you could trust?
Yeah, sure.
I would, well, if you want. Yeah. I don't have a problem. You could transfer it to me and then give it a year and I'll transfer it back.
Yeah.
You see what I'm saying? together with all the rights and privileges of the land patent.
Well, I went through the process of.
Or we could transfer it to a structure, but you gotta go a period of time,
Right.
because otherwise they're gonna consider it a straw man and a fraudulent
Right.
conveyance.
Well, I did all the things on land patent. Man, my dad actually gave me the land, I think. I don't know that there was any money transferred, but he might have said it's worth $20 or more.
Uh-huh.
But I don't believe there was any cash done on the land. He just basically gave it to me.
Well, that's how fathers and sons do,
Right.
right?
Yeah.
Usually the father gives the son a quitclaim deed. There's people I know in Arizona.
Right, they don't even have a deed, yeah.
And they've got the original land patent. It was
Yeah.
granted to their great-great-great-grandfather back in, 1920 or something like that. And they just said, well, you can have that 5 acres over there in the northwest quarter.
Right.
And so then he goes and puts a fence around it and builds himself a house, and he's living on it, right?
Right.
And the dad gives him a quitclaim deed or something like that, and it's not recorded. It's just in the family. I mean, there's people I know in Arizona that have never been on the tax rolls, and they just pass it on father to son.
You can do an inheritor's deed.
In-
If you're
in
the
the-
inheritor.
Well, possession's 9/10 of the law.
Right.
So,
In the simplest case, I think what I did is I looked back for 100 years to see all the titles, and I wrote it all down, and I put it on a website, and I put it at the county court and everything. And then I posted notice in three post offices and at the county as well, and ran in the paper, said, if anybody has a claim, bring it forward. And I waited 6 months, and nobody did. Now, of course, they've auctioned the land and taken possession. But I believe that that's the essence of a land patent, that you just say, if you've got a claim, bring it forward, and if you don't, you've lost your window of opportunity.
well, even that, in commerce, that's true. But if you have real ownership of the land, then you have real ownership of the land. Possession's 9/10 of the law. You see what I'm saying? And that's squatters' rights. If you've been living on the land for more than 7 years,
Yeah, I've been
you
there
have
40
squatters'
years.
rights.
38 years I've been there.
Well, exactly.
Right, and possession is, people told me I shouldn't have left, but I mean, I had 6 sheriffs and shotguns, and I had policemen in the house.
Yeah, I would file a criminal complaint against them.
Yeah.
And it was over property taxes.
No, I had a judgment on me from some years before.
Well,
And that's...
did you use the land as security?
No, never.
I'd file a criminal complaint
Yeah,
against
yeah.
them and the lawyers. I'd
Right.
name the lawyers.
Right. Yeah, the lawyers are the villain, not the one
Yeah.
who bought the land.
Yeah.
And the deed at the courthouse now says, I, John Doe lawyer, had Ted Eldon's permission to sell the land to Dr. Jones. Wait a minute.
I would attach that deed
Yeah, that's just
and
open fraud.
file a criminal complaint against that lawyer
Yeah.
for perjuring his oath of office and all sorts of stuff. And it's pillaging.
Right, but see what they did with him, I've seen that same tactic before. With the long arm of law, they force them to
Well,
get away from the property, and then under abandonment,
and then
hey,
Yep.
that's the
Yeah,
game they
that's
play.
right.
You're on
well,
the property,
but
you're
that
not there.
lawyer said otherwise. And the
Yeah.
evidence is that they went and forced him off his land.
Right.
I'd file a criminal complaint against him, and then I'd bring an action in federal court.
You can also file something at the bar that,
I would file, complaints at the bar too. Yeah.
Thank you.
That bar thing is not the easiest thing in the world, and they charge you for every phone call, everything you do, they charge you for it.
Bar thing, what do you mean?
Yeah, the bar association,
Uh-huh.
I tried it.
Filing a complaint against a lawyer at the bar?
I started it, but then I found out every call that I made, they were charging like 90 cents for the calls, and then if they had to make a list of attorneys that they would recommend to you. And
If
then
you
they
have
charge
to have
like-
an attorney recommended, you're an imbecile.
Huh? What?
If you have to have an attorney recommended, you're an imbecile.
No, I mean, it was a complaint that I was,
Yeah, but the point is that they're going to recommend some liar? I mean, I wouldn't let them do that shit.
No.
But when you went and even considered that, they said, oh, we got an imbecile on the line here, so we can start nickel and diming here. I mean, really.
They should have an ethics complaint.
Well, no joke, they should.
Right.
I don't think they know what the word means.
I don't think they do
Not
either.
their vocabulary.
I really don't think they understand.
But you
They don't want to understand.
I'd say, screw you, I'm not paying it, and you either do something about this or file a complaint with the Supreme Court, because the Supreme Court's supposed to be the one regulating the bar. And I get her name. What's your name? And who's your boss? Get your boss on here.
That's for her birthday.
Yeah, right.
Well, I'm just saying,
Also, there's a
man,
way.
you wanna file a complaint and the first thing.
Yeah, that's a bunch of crap.
It is.
I wouldn't put up with that for a second.
You can also do it online. There's a website, AVVO, I think, and they have ratings and complaints and
Yeah,
all
but
that.
the important thing is to get it on point, though. Okay, you got to be getting it on point. And the issue is that they forged his signature onto a contract. You need to file a revocation of signatures
I've done that.
and a notice of void judgment
I've done that.
and the whole 9 yards, and file a criminal complaint against them. That's where I'd be going with it.
At the end of the day, would the people who bought his land fraudulently, what would happen at that point to them?
I would
Who
expect
prevails?
that he's the one that really owns the land. The buyer has to prove that they own something. I think that they just flushed the money out of the toilet. They'd have to sue the lawyer.
Right, so they could recover their damages based on
Maybe.
the fact he...
They'd have to sue the lawyer, get the
Right.
lawyer's bond.
Well, they sold something they didn't have a right to sell.
And the whoever kicked him off his land,
Right, buyer beware.
See, at the auction itself, well, there was only one bidder because my sister let go of my driveway, basically, so the land was landlocked. Worth 200 grand, but he bought it for 25. But anyway, at the auction, I said, there's a land patent on this, it cannot be sold. But anyway, after the auction was over, they carried me off to jail.
assault, kidnapping, false imprisonment.
Yeah,
But
yeah.
again, that's the purpose of my notice and demands.
Yeah.
Okay? Anytime you even have a hint that something's going on, you start serving those notice and demands on everybody and their brother,
Yes.
and they're not going to want to be talking to you.
It's hard to do after the fact.
It's hard to do after the fact, you're right.
Notice it.
But it's all martial law. They presume you're one of the slaves.
Right.
You see what I'm saying? Now, you're still going to be able to get a remedy. I'm sure you will be able to, but it's not going to be easy.
No, yeah,
You're going to have, it's going to be a battle.
right. Well, I
Which-
believe I still own my house, it's just a question of how to get it back.
I would be filing criminal complaints. I would file a common law lien on that land.
Right, I want to do that.
You'd want to cloud it really
I
well.
have a template if you want it.
And
I do.
is it the one I gave you probably?
No, it's the one that Paul created.
Oh, I've got a common law lien that's good for 99 years that Ed Branham gave me. Now, I don't know who Paul got his from, but this
He
one that
wrote it, he created it.
Well, and it's, I would say that it's probably,
working for Susie.
he's pretty smart.
It's
He's
working
pretty
for
smart,
Susie.
but this one that Ed Branham gave me is really good.
Okay, well, send them both to him and he can pick and choose
Yeah,
or combine them.
Remind me.
Yeah,
Send
send
all
it
of
to
us.
the group, yeah.
Okay, well, I'll send
You
it
could
to-
use that. I could use it.
Yeah, I can do that.
I think I already sent it to Vital, but I'll send it again.
Everybody.
Right now,
Well, I don't have everybody's email address. I sent it to him, and I'm trusting that he's gonna send it
I'll
out.
send it to the-
That's all I can tell you.
Email on his-
Yeah,
Okay,
Bill
then
has,
we have that.
yeah, everybody's.
Yeah.
by the way, your email address is again, this is
Portugal 10,
the Portugal 10.
at AOL.com.
It's an easy one to remember.
Yep.
This
Yeah.
is the
10 the digit, 1, 0.
this is the NSEA stuff
For 10
That I'm sending you.
All right.
10 commandments.
So you're welcome, again, the stuff that I send you, you're welcome to circulate.
I thought it was October.
October 10th, yeah. Happy Cinco de Mayo.
Bill, what's your email?
Bill,
Yeah.
Bill, B-I-L-L,
Yeah.
D-E-A-L-S-R-E, yeah.
Common law lien.
DEALSRE.
Yeah, that's Bill Deal R-E, which is really small. Bill Deal R-E.
October, that's because they altered,
Soon to be.
they altered
What's the RE stand for?
What's that?
What's the RE stand
Real
for?
estate.
And then November is not decimal. That's because they altered.
Bid is March.
Should be property, yeah, that's what I.
Oh, yeah, definitely. Never statutory.
Including Julius Caesar, Julius Augustus, July, August, yeah, the others pushed all of that. So I used that as a legal offense. Identified them on the quote to the money. I said, listen, it's not good for Paul, but once if they call records good.
Yeah, I get upset with these guys and I start going off on them because
You know, once you understand what's happening,
Yeah, kick the
there we go.
Some bumped up.
Okay,
Some of them out. The others are paid.
this internet here is not working very well.
It's on this lower floor. It's weak.
I need somebody to put the repeaters in it.
You can buy them.
Oh, two at a time, wow.
Pretty simple. Go online and look for Wi-Fi extender.
Thank
They actually have some, they just plug into a wall outlet, and you put the bays up near the other one, and it collects it and repeats it, broadcasts it.
Okay, well, when this thing uploads, I'll send it to you.
Huh?
Works through the wall outlets.
No, it gets the signal.
Picks up the signal and
There's one
magnifies
that
it.
broadcasts it, and the other one receives it and broadcasts it here. They have all different kinds.
Some of them you can spend a lot of money on.
Yeah. But some are reasonable.
Anyways, okay.
One more interruption. What if this is a new development? Let's say developer bought piece of land, divided it, sold into lots. It used to be marshland or
We'll cover that.
Okay.
We'll cover that.
All right.
Because he's got a point. Once they develop it, it's lot 1 of XYZ subdivision, which is, you know, in the matrix. It's better to get a meets and bounds legal description, get a surveyor to come out and give you a meets and bounds legal description, but it's not absolutely necessary. We'll cover that. Anyways, Federal Reserve notes and other notes constituting a part of the common currency of the country are recognized as good tenor for money unless specifically objected to. So you can object to them. There's nothing forcing you to take those things. But if you give someone else Federal Reserve notes, it's kind of hard to say you don't want to take them back. So that's the little bankster scam they got going on, right? Anyways, so there's nobody forcing you to take them though. I always tell people, you guys take IOUs? I'm basically asking if they'll accept it. I figured you would. Since you took my IOUs, I'll take yours. Sometimes they say, they laugh. Sometimes they say, no, we don't take IOUs. So now I got an opportunity to educate them a little bit. Well, that's an IOU.
Instant education.
Yeah.
That's good.
Yeah. Every time I spend money, I do that. Anyways.
Go to the bank and ask if they have any Federal Reserve notes, and sometimes, well, let me check.
Yeah, or do you guys take? I've gone in there and said, do you guys have any? You know, a lot of times I'll approach it a little bit differently, but I'll get into a conversation. I'll be telling them about lawful money, silver eagles, right? And I'll say, do you have any silver eagles in here? And I'll say, what's that? And I'll pull one out of my wallet because I always keep 2. And I'll say, that's this. And I'll say, this is $1 in lawful money. And they'll say, no, we don't have any of those here. And I'll say, well, I guess technically you're bankrupt then, aren't you?
So all you have is fake money.
Yeah, that's right. All you got is fake money.
The silver eagle, you said, right?
Uh-huh.
Okay.
Is it pre-1933?
No. This is 1986 or something like that. These are the silver eagles. They're 100% silver, 1 troy ounce, and it has a face value of $1. You've seen these things, I'm sure.
Yeah, well, Bill Elwood used to tell us we needed to have pre-1933 dollars
Why?
because it's prior to the bankruptcy.
This is
Yeah, Tim Turner used to say that too.
this is silver. It says $1 on it. This is 0.99% pure silver. It's kind of dirty because it's been in my wallet. But this is a silver eagle.
But
that's worth $1 of Federal Reserve notes.
Well, it's actually worth about
it's
14 or $15
$15.
right now.
But does the date, when they put the date on it, that postdates the bankruptcies and all of that, so could there be a hook there that the reason why these other gentlemen said
Right.
pre-1930?
Yeah,
There's a guy who sits in the treasury, and his job every day is to allocate the national debt against the Morgan and the peace dollars prior to the bankruptcy. Okay, so those are the ones that really define your sovereignty.
Yeah, and you're supposed to have.
That one probably removes any doubt.
Actually, if you think about it when like U.S. Airways went bankrupt or American Airlines, right? The way it works is, see, they get debtor in possession financing, right? Because what happens is that when they go bankrupt, all the debts prior to the bankruptcy are caught up in the bankruptcy. But these corporations are more than happy to give them debtor in possession financing because that's after the bankruptcy and they can't go bankrupt against that. You see what I'm saying? That's going to be 100% payable in full.
Which goes to 86 being okay.
That's right.
I get you.
Exactly.
Well, I was in bankruptcy, but I got out. But I did notice that banks were calling me, we want to loan you money. Wait a minute.
Of course.
I'm bankrupt. What do you want to loan me money for?
But the
Because
reason
that
is...
one cannot be bankrupt.
That's right. You
Right.
can't go bankrupt against something that's after the bankruptcy.
Right.
You see what I'm saying?
Well,
So they're...
You can't do it for a certain amount of years. But
Well,
after you can.
they damage your credit. Your credit's damaged for like 7 years or 8 years afterwards. But you can still get credit cards after.
Yeah.
And the banks, the reason they do that is because they know that you can't go bankrupt against them.
Right.
So they know they can collect it all. But let's face it, I've been at the point of bankruptcy once. I was actually considering bankruptcy once, and I didn't do it. And at that time, during that time period, I got sued, and it didn't mean anything because there was nothing for them to collect. You see what I'm saying? Number one, and number two, I basically just walked away from those. And what happened is they made me mad, right? How could that happen, right? But
Don't get me going.
But they got me going. They went and called up my work and got me fired from a job, and I said, "Screw you! I'm just not going to pay you." You know, and I could have sued them over that, but try and find a judge that wants to be a judge. Anyways, so you know, this was like probably 20 years ago, but and since then I've learned a lot of things, and for example. I went and sent a letter to, there was a bank, I had a $29,000 line of credit, right? This was in Canada. I had a $29,000 line of credit on this credit card, and I lost my job, so I was out of work, and I couldn't make the payments. And so what happened is I got this letter from these lawyers. It was a demand letter, right? Pay up now or we're going to sue you. And so I sent them a letter back by registered mail, and I said, sure, no problem, you can sue me, but I intend to prove in court that you didn't loan me anything. And and I intend to ask Tom Schaaf's 160 questions here of an officer of the bank and a CPA in court, and prove you didn't loan me anything. And oh, by the way, I have an affidavit I've enclosed in here. If you want to have an officer of the bank sign this affidavit saying that they did in fact loan me a depositor's money, I'll reconsider my position. And I sent that to him by registered mail. 90 days later, I get a statement back on that account showing it's been paid off.
Yeah. We did that. We do that with credit cards, all kinds of stuff.
Yeah.
After further review, your account is zero.
Yeah. Yeah, but the lawyers have to be involved because the lawyers are the officers of the court. If you just send it to the bank, it's some clerk, and they'll never threaten to sue you. They'll just put you on the collection agency round robin.
Well, that's if it's a lawsuit, but this was actually directly with the bank. It was disputing the debt, and they, upon review, your balance is zero. It was $12,000.
Yeah. And then since then, I did here in the U.S., I did the same thing with, or something similar, to Citibank. I had 3 credit cards. Each of them had $15,000 on them, and I did A for B on them. And what happened is they were sending me their solicitations, and I accepted them for value, sent it to the IRS, is where you're supposed to do that with the Dissolve Your Debt Manual. And what happened was I sent them a 4-page letter, and I got a copy of that letter if you want to see it. But I sent them this 4-page letter, and I told them that, number one, I said, you securitized that application, so you've been paid on it 3 or 4 times at least. And I said, number two, I said, you didn't loan me anything. And number 3, these are Federal Reserve notes, which are United States debt, and so therefore United States owes the debt. Go collect it from United States. And I said, number 4, I said, I've been to the Supreme Court 5 times, and if I hear another word about this, I said, first of all, I said, if I hear another word about this, I'm going to sue you for fraud, theft, extortion, all sorts of stuff, right? And I said, if you have any doubt about my ability to sue you, I said, go look up my name at the Supreme Court because I've been there 5 times, and so I don't want to hear from one of your lying, thieving, murdering bar member, buddies. You know what I mean? Anyways, what they did is they put me on the debt collectors round robin, so they actually, but I told them, but don't be damaging the straw man's credit report because I'll sue you for that too. And they no negative credit reports, but they did they had solicitors call me up or send me stuff, wanting to collect the alleged debts, but that was it. That was all.
Another way that a friend of mine has done it a few times is send a $1 bill and write a letter saying, accept this as full payment for whatever is owed. And it was gone.
Really? $1 bill? In cash?
What's the basis of why they would do that?
If they
Oh, fraud.
accepted, if they accepted his
paid.
agreement,
Yep.
if you
They
agreed to
didn't
it,
send it back.
So if they send it back, it would be not accepted.
you
Well,
renegotiated.
if they send it back, it's also almost the same thing because it's if you refuse payment, it's paid.
Right, I did the
That happens
same.
in court a
I
lot.
sent a money order to somebody, and they said they only take credit cards. I said, no, here's the money order, you may return it or keep
Yeah, no
it.
problem.
Whichever you do, it's discharged.
Do they keep it?
Yeah.
Even judges in court, a lot of times, like in tenant landlord cases and stuff like that, they will say, has he made a payment? Oh yeah, he paid $300, but I refused it because it wasn't full payment. And the judge will say, you refuse the payment? It's paid.
Yeah.
Well, that's UCC. UCC, if you can.
Under the Uniform Commercial Code.
Yeah, I've used restrictive endorsements on the back of a lesser amount that I've offered for payment.
Right.
And that restrictive endorsement sticks.
So A for V, though, is U.S. citizen, correct? I mean,
Yes, it is.
So
Yes.
basically, you're either one or the other.
Yeah,
So-
it's at some point, if they're
You
dragging
have to-
you in there, then you got to know how to deal with it
Okay.
as a U.S. citizen.
If you once did that, then you were once U.S. citizen. Does it obliterate all the other things you're trying to do, not being one, or is it an individual case?
No, it's the Sesticate Trust again.
Right.
I'm not a U.S. citizen.
Right.
It's the Sesticate Trust. I'm signing for the Sesticate Trust.
Okay,
I
so
see.
the A for V.
So you did A for V as Sesticate.
Authorization.
Right.
I
Yeah,
got
man
you.
can't do it.
I see.
They're gonna go back and find it anyway and make it stick to you, so.
Okay. So it's dual citizenship, like something.
It is essentially,
sense.
except that the U.S. citizen's a slave, and if that when you're operating for
Fictional
that,
entity.
then you're a slave, and so that's why I do what I do because I really don't want to have anything to do with that thing.
Right.
If they're going to assault me with
They
it,
force you
then-
to assign that.
then
that-
I'll deal with it. Obviously, I'll have to,
I see.
but they may not like how I deal with it. You see what I'm saying?
Well,
Kinda
see, I
like
was thinking if you...
You're a man on the land, but you can go in the water, but you can't live there.
It's good.
You can go in the water,
It's good.
but you can't live there. So if they're dealing in admiralty and that type of stuff, you can go in there.
Yeah, if they throw the
But you
water
gotta come
on
out.
us, Yeah.
You gotta dry off and get back on.
Yeah,
See, that's what I'm
what you have to
saying.
understand
Yeah.
that there's a
We're not
difference,
a mermaid.
and
Be fishers of men.
if you have to, you go in there.
But the fact that you had once been in doesn't mean that they can bring that forward as evidence.
No,
Of
'cause I'm the king,
Right.
right?
Well, it
It's
wasn't
treason.
him, but it wasn't him.
They got no
anyway.
authority to drag me in there.
It wasn't him.
And it wasn't him
And it wasn't me.
Do you want to list the five subjects for which you went to the Supreme Court?
Well, there was 2 of them for the IRS. There was one. There's probably 2 of them that I was suing judges. I have to think about it.
Okay.
But I know that
Well, that's an impressive
there's
record.
probably 2 of them that I sued judges.
Any of them successful?
Oh, well, depends on how you look at it, okay? First of all, when I go to the Supreme Court, I tell them there's a motion to proceed without the extortion, right? And I tell them you have no right to tax me, and you have no right to turn this case away. And I said, because I'm one of the people. And they never charged me a tax, and they never turned it away. And when I made those arguments. And it's essentially the same argument in the actual petition, okay? Because the stuff they're doing, they can't do to the people. You see what I'm saying? And so every time they accept a case, they docket it, and they send me a letter to send to usually it's the Department of so-called Justice that has to respond. You see what I'm saying? And every time the Department of so-called Justice waives their right to respond. Okay, so you got to understand that it's essentially the same argument in my petition to get them to accept the case as it is in the actual petition. And so I've won at that point, right? If you think about it, because they accepted the case, and there's no filing fee. And so, so the Department of Justice, when they waive the right to respond, they admit everything. They say, okay, so what? We know about that.
So you get a default judgment?
So, well, no, it's not a default judgment. The Supreme Court doesn't work that way. Okay, I get what it is it takes away the controversy. Okay, and the Constitution actually says the Supreme Court needs to rule on a controversy. When the Department of Justice waives their right to respond, they're admitting everything. There's no controversy, right? So then the Supreme Court dismisses it.
Now, did you file as living man or Sestake?
Well, as a living man. That's why I said you can't turn this case away. You have no right to tax me because I'm one of the people.
Right. So
You see what I'm saying?
A winning strategy.
Well, it is and it isn't, because I don't have any landmark Supreme Court cases saying that I'm right either.
Well, they couldn't do that, right?
Well, of course, can't have that, can we?
Or does it have a check?
But you got to understand also that the Supreme Court wears two hats. Okay? A lot of people don't realize this, but there is a Supreme Court of the District of Columbia. Okay? It's in the same location.
Is that Superior Court?
No.
No, not the same one.
The United States Supreme Court is also the Supreme Court of the District of Columbia.
Okay. Oh.
See, it depends on the arguments you bring. And so they are either, they can be the Supreme Court of the United States Supreme Court is the Supreme Court of the District of Columbia, or the Supreme Court of the United States of America. See what I'm saying? And
depends which one you back it. Your paperwork will do that.
That's right. Yeah. Exactly.
Wow.
Exactly.
I just got this, that we were talking about different, IDs. This wasn't available yesterday. The site was down. It's Dominion of Melchizedek. I'll forward it to Vital. This is another source. Let me just read this. Dominion of Melchizedek is an ecclesiastical sovereign state dedicated to upholding political, social, and economic sovereignty in the Dominion of Melchizedek. And they revised a lot of their stuff under the Charter 2012. So that's another source.
Where's that at?
The Dominion of Melchizedek, I've got a friend that was deeply involved with them. I don't know where they're domiciled now. Dominion of Melchizedek is an ecclesiastical state that operates through our newly instituted charter. The focus of our state is commerce, philanthropy, education, and sustainability.
Do they have a website or?
Yeah, it was down yesterday. I contacted my friend. He's a JD out in California.
Can you tell us the website?
Yeah, it's Melchizedek, MELCHIZEDEK.
Go slow.
Yeah, MELCHIZEDEK.com.
Wow, perfect, thanks.
Okay, I'll forward that to Vital. He can pass it along. There's stuff happening all over the place, and there's people like us that are rising to the occasion. The ladder is a long one, and the view is different at different stages.
I'm going to try and move this over to there so I can send these emails, and then I'll come back.
Do the winds as you right as you're going.
Glenn, in reference to the bankruptcy, have you ever heard that in the Geneva Convention books that the Firestone family paid off the U.S. bankruptcy?
I haven't heard that,
It's in the Geneva Convention books.
but there's a friend of mine in Canada that says that precision drilling owns the Alberta government.
Really?
Yeah.
Meaning in terms of.
My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo. My YouTube profile, Sovereign Living and Sovereignty International. My Facebook community page, I deleted it due to censorship on the part of Facebook. My private group at Facebook called Sovereignty International is being deleted. Facebook is a has-been. I don't even go there. I haven't been there for months. But if I wanted to go there and ban everybody off my group, that's the way I would delete it, because I'm not going to let Facebook profit from my hard work. Meanwhile, I have friends that are basically on there managing things, and they can have at her for all I care. Anyways, my Yahoo private group is called Administering Your Public Servants. My Google private group is called Administering Your Public Servants. And follow me on Twitter at Engineer Wim. Follow me on Steemit at Sovereignty International. And there's a link to my BitChute channel, although I don't have all my videos uploaded there. There's only a few. There's quite a few. I've got quite a few, but still, it's not all of them.
Less stable.
China has.
Until you get to the top. But you're like
come to the
executives,
plate.
they're always considered
By
by
free
free
transactions.
When you're in the middle, it's a little shaky. You either go up to where it's secure or come down to where it's...
Well, going up the ladder because the peasants at the bottom are holding the ladder.
Big enough to wipe out.
But see, they don't realize they can
one
hold
check.
that ladder, not be
Matter of fact, I was sitting on the table.
He's told them that.
You getting on this?
So 5 of us there.
But I'm at the top.
Okay.
Well, there's a lot of information.
All I do is take it over there.
Yeah, you go.
Send no problem.
Really?
Yeah.
Moving it forward a few feet, huh?
Yeah.
Oh, makes a difference.
We've got the signal.
Verify the signal is good.
Peter, I'll get the extenders for next time. God willing.
It was that big a check.
Okay, well, let's take a little break. I gotta use the restroom.
Oh, good.
Yeah.
I'm gonna go get a jacket.
Yeah, one is it public or is it private?
I know it.
Public restroom, private restroom.
There you go. Is that the straw man key?
It's good, it's good.
Live man.
So we have little straw man pictures.
You should have 2 toilets in here. Fiction? Real?
It's
One's red, one's blue. You choose.
The fiction doesn't need a toilet.
Right.
Just a trash can.
Right.
Just to put the paper away.
Yeah.
And then you can take advantage of
It's
it.
charging.
Here's an example of what we have, which
Oh,
I'll share later.
well, I'm okay. I'll do that if I get low.
Okay, this
Me
house
too.
has the private bathrooms. The other one has a little bigger room to meet. It's square. This is one wall. This is rectangular one or less. So we have. Let's see if it'll connect.
Yeah, I just sent that to you to tell.
I think a lot of people are on maybe. Okay, there we go. Oh, there it is. Now it escaped. Go back. So. Oh. Okay, we'll go to this house. This is like what's online if people want to rent, shows availability. So this is all booked,
The green is booked?
Yeah.
You use Airbnb?
No, VRBO or HomeAway. Because we don't take single people, it's all just, you rent the house.
What about a single person with a lot of money who wants a house
That's what happens.
In situations like this, you could rent single homes.
We don't want to. So you rent the whole place and you go take care of the gathering.
Even though we're strangers, we're really not. so it's
Some people,
We're
a friend of
strange.
mine is doing Airbnb, he's making unbelievable amounts of
Good
money.
for him. Good for him. That's good, that's great. So anyway, here's the example of this house in September is, we have 3 weekends out of the 5. October, currently 3 out of the 5. November, 3 out of the 5. 3 out of 4. 3 out of 4. So September's really good weather. It'd be great for the Wednesday. People can really make it a vacation, justify the travel, justify the expense.
So June, July, August, that's your busy.
Yeah.
No, Bobby.
This is 60 a night per person in the
Look at
summer,
all.
and it's 22 to 29. And as an example, it's half the price. And we don't rent here; they rent for a whole
Yeah.
month, or 3 to 5 days.
Yeah.
Generally,
Flip it again.
once you hit September, it's all.
Light.
Now that's this
Light.
house. The
Oh,
other
that's
house.
cool.
So
Okay.
I mean, it could end up that we
So
got
let's
an
keep
extra
moving with
house.
this. We got a lot of stuff to cover still.
Yeah, oh, yeah.
See that night?
It's more designed for families.
Duality and everything.
This
Look way bigger.
And that has almost
That
no
was an old
bunk beds,
Gothic
it's nothing
piece.
but that.
That was red.
Old people don't generally rent this because they can't do the bunk bed here. They don't have to clean it.
So you rent like this area separately or the whole house?
No, let's see if it can work. 15 minimum. Basically, the pitch is 15 minimum, at least 2 nights, and then there's a cleaning fee. And if you're abiding by that and don't smoke, you're welcome to rent it if you're over 25. And then that's kind of how we do it. Sometimes, and we charge per head. No, we charge per head. So if there's 25 people, that's where we make our extra money.
I see.
We charge per head once. It's like the airplane. You know, if the seat's empty, they don't make anything. But if somebody does want to take the seat, then they make it. That's where they make their extra.
Are you comparable with everybody else around here?
Are we what?
Are you
Oh,
comparable as far as your rates?
Actually, we're a little cheaper.
Well, that's good. That's where you're going to be.
Yeah, that's why we stay booked and get repeat business. People have been with us 20 years.
So you have to repeat.
Right. I mean, they like the area. They find the reason they want to be here. I mean, you guys aren't down in Virginia Beach right now. You're not up in Cape Cod. I mean, you're here. So if you want to come back here, and then see what happens.
You got any cards or anything, relative to?
No, I just email you the link, and then call me direct or email me direct. You'll have my number because I will have texted you or emailed you. But what I want to do later is actually at some point, could you go over with me, look at the room, and decide if we want to, for fun, move over for the afternoon session to the new venue because the people left.
Is it warmer?
It's got a. Well, we could make this warmer.
The windows are open,
No,
that's
no.
why it's
I know, I
chilly.
shut the windows here. No,
Yes,
just-
but
Yeah, we could go over there if you want.
I mean, we'll look at it.
Have
at
a break
lunch.
and go over there.
Right, at lunch, you and I will go over, and if you decide, then just make sure the TV works, and then it'll be a more square room, and we'll get the feel for it, and then everybody can look at the house and then decide if we only have it in the one house next time, which house.
Oh, I see.
So, you're kind of be the one who makes the decision.
Okay.
You can hear the feedback, because it
Right.
really, they can input, but they don't have the fun. You're the king, right?
I guess.
You keep telling us that, we're going to believe it.
In fact, that's how this happened. Glenn, he said he's the one that decided when and what, so, and that's his deal. So, and then what we're going to do is the next time, everybody again, it'll be the same deal for the next time. Anyone that was here, any new people or people who said they were coming and didn't come along, they're not going to get the benefit. Because.
Oh, benefit, where do I sign?
Brooklyn.
And then would that be in October?
I like benefits.
We're going to talk about that probably after, if we go next door. Everybody can go over and see the room. It's not
Right.
just us. It's just I want him to go first to decide if it's something he wants to do.
That's fine.
And then eventually, the plan would be to everybody bring one or two, additional, and now that you've been here and can explain it, he might bring his wife, et cetera, and they can, like, they might want to just come and just be here while they're doing other things, while we're all in the conference.
Oh, that's true.
Well, I'd quite frankly like to come a little earlier and stay a little later next time, so I can tour around a little bit, you know?
Right, well, you can still stay, unless Peter has to go.
Well, Peter's got to go, so,
So you're going.
yeah, I have to go too, yeah.
Okay.
But I'd like to.
So yeah, well, what we'll do is everybody will get their calendar up. You'll be listening to what everybody's saying, and hopefully by the end of tonight, we will have a date, and I'll reserve it, at least the one house. And then we'll start promoting it, and people this time I'm going to have them send, except for you guys, everybody else is going to have to send in money now.
Yeah,
'Cause,
no.
you know, I based it all on their word,
Uh-huh.
and those that didn't fulfill, and didn't tell me they weren't coming, they're just going to have to, everybody's going to have to send in money except you guys, till you get here, and you guys will be the same price, same thing, free lodging, 100 to Glenn, and then anybody new, he and I will decide how we're going to handle that.
Right.
And then if the second house books, then at that point, my family, you know, kind of should get a little money for the utilities, the cleaning, and all that stuff.
Right, well, of course.
So
Now, we noticed the crane next door. Is that how you get to the second floor? We got a bucket on it.
we could get you there that way, but there is an easier path.
There's a catapult.
Right.
Much quicker.
That's to remove the bodies.
Nelson, as soon as I was aware of the meeting, I committed. I got transportation and I paid to Glenn right away. And I thought everybody else should just pay you all right away. He was coming from Texas. You all were making a huge effort. I thought it was,
you know, it was fun the way it worked out. It's just because Glenn, I paid him ahead of time, so he was secure.
Right.
Because I was doing it if nobody showed up. If he showed up,
Yeah.
me and him would be talking right now. And that would be
Well, I
it.
think we got a real nice group here. I think everybody's contributed.
Oh, it's been great, and it's
Well,
only
it's-
2 days in.
It's a networking thing, you know?
Yeah.
And,
it is possible, you know, as much as, well, I mean, everybody likes
Yeah,
to.
it's a real one.
And you're here, I guess, jamming the time, but it is a lot of, I mean, we were up till 11 talking about.
You should be taking pictures and put it on your Facebook page for the group.
well, we'll see how many of that turns out.
Right.
I don't have, I stay away from Facebook, quite frankly.
4 million?
But,
On your website, you could advertise your website.
So,
Good.
also down the road, because one of the reasons Ocean City is so popular in other shore communities is they're easy to get to, you know, they've been developed, they have accommodations, and we have numerous situations where both our houses are booked, but it's too many people, so they have to find other lodging. So eventually, we would move this to a genuine meeting room somewhere on the island, where housing would be separate from, you know, this would just be somebody's house, and we would head over to a church, or we can rent a room.
some
at the
room where
community
there's
center.
better facility,
Not
yeah.
the church where they're going to sue us, though, okay?
Right.
That one.
I'm not sure about that. That would actually be fun. But actually,
Yeah, let us sue Glenn. He'll take them down for you.
Actually, just if anybody ever cares to know, any Methodist church in the world, you can basically take over with a hostile takeover. All you have to do is walk in with people, join, and then you can basically run the show. Just so you know. The only thing you can't do is say no to one or more appointed pastors that the bishop wants to send. That's the only thing. And I just recently found out that you don't even have to approve the pay for the guy. They're allowed to appoint anybody they want, but we don't have to approve to pay him. He has to work for free, or like that's the point is that there's a balance of what do they call it in government?
Power. Balance of power.
No, checks and balances.
Checks and balances.
Like, so the idea is everybody move this whole thing forward, and generally there isn't conflict. But if there is, the power Wesley gave to the people, because he created the Methodist Church at the same time as this American colony thing was going on.
Uh-huh.
So that's how come he just said, you guys did all the hard work, I'll copy the system, the 3 branches of government, and that's how we govern ourselves.
Right,
So it's
right.
almost exactly the same.
That's interesting.
So,
Except you guys follow it. The government doesn't.
No, actually, that's not true.
No?
No,
They don't follow either.
that's why they had me arrested and I was not given due process. That's the whole reason I'm winning, is they didn't give me due process. So they don't do it. They have the same problem we do with the federal government.
Corruption.
Exactly.
Okay, so let's keep moving here. The dollar is the legal currency of the United States, a unit of money consisting of 100 cents, the aggregate of specific coins which add up to $1. So it's coins. In absence of qualifying words, it cannot mean promissory notes, bonds, or other evidences of debt. Okay. Banknotes constitute a large and convenient part of the currency of our country, and by common consent serve to a great extent all the purposes of coin. In themselves, they are not money, for they are not a legal tender, and yet they are good tender unless specifically objected to as being notes merely and not money. Obviously, that's why they put this note as legal tender on the Federal Reserve note, right? They subserve the purposes of money in the ordinary business of life by the mutual consent express or implied of the parties to a contract, and not by the binding force of any common usage. For the party to whom they may be tendered has an undoubted right to refuse accepting them.
But we just discussed, if somebody refuses to accept your money, your payment, your offer, then they have also waived their right to collect it all.
That's UCC.
Well, but I mean, how does that relate to what
All
we just...
depends, well, a private person can reject it.
Okay, but I mean, if we're paying somebody, or
If
offering
you're
to
tendering
pay,
it. You're
Right.
tendering it.
And if
If
they
you're
re-
giving me nothing for whatever you're trying to extract from me, and I recognize it as that, get out of here.
It's fiction to fiction.
Right. But, you know, for all debts, public and private, you know, if I've contracted, you know, with you for a debt, and you tender that, then I've already predefined my acceptance of the tender offer. You know, but if you're just coming into my store and you're trying to get something, I'm going to refuse it. Get out of here. Give me something
Okay, but I
else.
was talking about a debt. Yeah, you contracted your... Yeah.
Right. If I've not contracted with you and you're trying to engage me in contract, I can refuse it. But if I've already engaged in contract, okay, then UCC kicks in where
I
you
was
tender
trying to
payment.
buy internet website services, and they made an offer, and so I offered him money, and he refused the money, and I said, well, I don't care if you give me the money back or not, but I've paid, I've discharged because I offered.
Well, you pull up the UCC, and especially if it's a corporation, you know, you can force them into compliance.
Yeah, well,
I've done that with a bank.
Yeah, he accepted that, yeah.
Could someone, my sister who's in charge of accommodations, hospitality, she's one of the reasons it's as clean as it is. She's going to come over and sit in.
Okay.
So I'm just wondering if somebody could give up a decent seat. Well,
There's one right here.
There's one right next to
Oh,
me,
okay.
I'll keep coming.
All right, good. Okay, thank you. Because, you know, she deserves it.
And Dawn can explain anything she doesn't understand.
A banknote is a common promissory note issued by a bank or corporation authorized to act as a bank. It is in fact a promissory note, but such notes are not, for many purposes, to be considered as mere securities for money, but are treated as money in the ordinary course and transaction of business by the general consent of mankind. It's all by consent.
Yeah.
The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They form a part of the public debt of the United States. Gee, that sounds like national supremacy over states' rights, doesn't it?
Mm-hmm. Mm-hmm.
Anyways, that's U.S. Supreme Court.
Yeah, that was the problem. States should have had the right.
That's right. So, solution one is object to the IOUs circulating for money. Okay, and by putting on, when you endorse a check for deposit, for credit on account, or in exchange for non-redeemable Federal Reserve notes at face value, that's an objection. Okay, that's saying you never got paid, you never got money. And I know you've got a different endorsement that you use.
Deposit only par value unknown.
Right, exactly.
Would you repeat your endorsement?
For deposit, for credit on account, or in exchange for non-redeemable Federal Reserve notes at face value.
Mine's a lot shorter. I just say deed for lawful money, and it fits in the memo section.
That's what I put.
So
And you can do that too.
What's he say?
You put it on the memo section?
Yeah, right in the memo.
What's
Redeem for lawful money.
what's the benefit of that? Like, what actually happens
You're
when you
basically-
write that in there?
You're asking them to redeem it for lawful money, which is gold or silver. By you adding that, they can, first of all, they can't monetize it, and they can't charge you a tax.
They can't tax you on
If
it.
you do that with your payroll checks, they can't tax you because you've made no income, because you're trying to redeem it for lawful money.
Right,
Wow. So it's basically proving it's fake
right,
Right.
yeah.
every time.
You're making a statement. that-
They, just because they can't give you what you asked for, that's not your problem.
Right.
You're asking for it.
I see. So then they give you the fake, but there's lots of good things that happen for you.
Right.
If you put
And,
that
and
on
this
the
is
front
why
of
I
the
write
check-
it in the memo section, because you write it on the back above your signature, they will more than likely refuse it.
I never sign it.
So you never sign your check?
I'm saying when I'm cashing it, if somebody else's
Oh,
check,
okay.
I just put it in the back, deposit only, par value unknown.
Right.
I've never had any trouble with that kind of stuff on
I
the
did.
back of a check.
I've had them refuse it.
I've had them, what I do is educate them. And I tell them, well, first of all, it says pay dollars, and you're not giving me dollars. And that's when it comes up with the silver. I'll say, you're not giving me dollars. And I'll say, I got $1 right here, I'll show it to you. And it's my silver eagle, right?
They point to the dollar that's on the dollar bill.
Well, that's not dollars though.
Federal
Because-
Reserve note.
It's a banknote. It says also Federal Reserve note. You see what I'm
It's a
saying?
note, it's not a dollar.
It's a note,
So
that's
they're-
right.
Right, okay.
And the dollar symbol with one line is a peso.
It's a peso, that's right.
So-
But
Is that
so,
on there? Is that what's on it? A single?
they
Single,
don't-
there's supposed to be two.
I don't think they have a symbol on the dollar bill. I don't think there's
Not on
any
the dollar
symbol.
bill,
In
but on the
Texas-
checks, on the check.
Oh, on the checks.
In
Yeah.
Texas, when you
Right.
get your tax bill, your tax statement,
Mhm.
there's no dollar sign.
No, there isn't. They have all these
So it
calculations
just says
and breakdowns.
862.62.
So
That, you could give them beans. It
pay
doesn't
the
matter.
coffee beans.
Well, not exactly.
Whatever you
not-
wanna
not-
do.
Not in Ohio, the lower portion has a dollar sign.
Right.
And then it has a blank, and you're supposed to decide if you want to pay half taxes or full taxes. But it's a statement, it's not a bill.
Right.
Lawfully, it should identify USD, because you could pay it in other dollars. There are many different countries that use the dollar as their currency. And I've done that. I've used Trinidadian dollars, which trade at a par of 6 to 1, paid off the traffic light, now I have bonkers.
That's-
Point in
Did they?
Oh, yeah.
Now you spend it with no dollars.
Well,
Okay.
I asked the judge, is this fine in dollars? He says, yeah. He never said US dollars.
Wow.
So I went down to payment, they said, we can't take that. This
That's good.
judge just said it was payable in dollars.
That's right. At common law, only gold or silver are a legal tender. And so, and that's a cite from an 1820 court case, but they're citing Book 2 of the Institutes and the Laws of England by Coke, which goes back to the 1500s. And so, the point being is that when you use Federal Reserve notes, especially when you're in the courts or those kinds of places, you're nullifying for yourself common law. That's what you're doing. That's the reason that judge, that's why I don't pay the filing fee. Because that judge is sitting up there, you're turning a court case into a commercial transaction. That judge is sitting there playing stupid. You know, you just nullified his oath of office by doing that.
By paying a filing.
By paying the filing fee.
And what happens if they don't refuse the case?
Well, they do. They do. And then I file criminal complaints against them.
Okay, they
Yeah.
learn.
Well, you know, they're going to get learned one way or another. Maybe we'll have to stretch their neck or something like that, but they'll get learned. But
If you pay the filing
but
fee.
yeah, so I file criminal complaints with. Matter of fact, my belligerent letters I sent to the U.S. Senate and the U.S. House of Representatives committees on the judiciary, and it's complaining about judges because of that. You see what I'm saying? Because they're compelling their IOUs so they can sit there and play stupid and deny you justice.
You say if you pay the filing fee.
If you pay the filing fee, that's right.
Ah,
Their oath is nullified.
You nullify their oath.
okay.
You can't pay the filing fee.
Yeah.
So they have, that's their way of, one way.
Yeah. Well, then they can do anything they want, and they'll tell you, I can do anything I want here. Well, that's because you paid the filing fee.
You've agreed to the,
You agreed to the jurisdiction of the corporate administrative tribunal.
Right.
but I thought that the people, the Article 1 judges that are there, right, and then we want Article 3, they're never Article 3. Is that incorrect?
Well, that's right. Well, that's why they're not Article 3, because they insist on assaulting you with their extortion. So they choose to not be Article 3.
They could be if
They
they
could
wanted
be,
to?
absolutely.
All their business is done with slaves, and that's all they do. They almost never open a common law court where it's man versus man.
Yeah.
You don't have any authority.
Even in small claims, it's close to common law, but it really isn't.
Yeah, you're right.
And so that's all the customers they have. Why would they,
It's all slaves. It's
The
all
other
slavery.
thing is in a dustbin
They can
somewhere.
do whatever they
So
want.
does man versus man require a jury? Does it go that
Well,
far?
that's what it's
Why
gonna-
is the judge even
It's
involved?
just, that's what it's gonna have to come, that's why I do what I do. I wanna educate people so we can start convening our own
That's where we're
juries,
heading.
and that's where we're headed.
So could he today say, I want to hold an Article 3 court?
They could, actually, they could.
Okay, well, how?
Technically, he couldn't, if he's getting paid. He can't be, if he's paying anything IRS.
Well, and plus they're bar
Validation.
members,
Yeah.
that's another
So
problem.
that's my question. Can they even hold an Article 3 if they wanted to?
If they're a bar member, no.
Okay.
Some of them are not bar
They have to
members.
throw the flag out.
Well, actually, it's not the judge who would be ruling in common law, it would be the jury.
Right, the
Judge
judge
is
is,
just advisory.
Article 3 is just a referee, he doesn't make any judgment.
Yeah, but again, the jury's all U.S. citizens.
Right.
And it's bar members that are running the whole show.
This is why we have to reconstitute the
De jure government.
de jure government. Okay, thank you. I'm getting it.
You know, in Rhode Island, in Providence, you got the old courthouse. It's right there.
Yeah.
Nobody's there.
Really?
It's empty.
They do that in Canada,
No
too.
customers.
Right,
do that.
exactly.
They
But
do
if
that.
you went back there, that's the one, that's the real one.
They do
You
that
should
in
be going.
Canada.
That'd be fun.
I got a ticket in Canada one time, and there was an address I had to go to for the show trial for the court, and I went down there, and I actually went across the street because there's a courthouse there that you could see as a courthouse. So I went across the street. There's all these windows, and you see the benches and everything inside, and the flags hanging, and all that stuff, right? And so there was a flag in there that was not
Gold fringe?
gold fringe.
Yeah.
You see what I'm saying? There's a federal and
It
a
was still
provincial.
there.
They were there, and the benches were there. Everything was there,
Except for people.
and there was nobody in it.
Yeah,
That's
same
right.
way in Rhode Island.
And so then I looked on the ticket, and I realized the address that I had to go to was across the street, and that's where they had to. But isn't that obvious when they have a real court across the street and there's nobody in it, and they drag you into this
So
fake
who's
court?
preserving them? And
Now you know why the chickens cross the street.
If they really
It's-
wanted to...
It comes down
To get to the gold fringe flag.
they have to common law still they have to have that court there, and
Right.
and at some point maybe the people will
Wake up.
and start running their court. That's right.
So it's already there if you want to use it.
That's right.
Right, it's
That's
just
right.
empty, nobody's there.
That's in
Okay.
the state
That
capital?
is too much.
Yeah.
Yeah.
That's a documentary.
It's like I said, it's an illusion. The Matrix is real.
The
The
Federal
Matrix is real.
The Federal Reserve was actually started in Rhode Island. Yeah, and the reason why, is Senator Nelson Aldrich that called for the meeting that took place in Jekyll Island. And he went down Newport and called all his buddies that had the little beach houses down there on Bellevue Avenue. He says, hey, let's find a way to circumvent the Constitution. And they did. And the reason why is because Providence had such a beautiful harbor. There was so much merchant banking down there, private banking. When I got into real estate, Rhode Island had so many different types of banks and flips, and I mean all kinds of stuff. I mean, and what they did was they just brought them into more of a national state for commonality, but there was all kinds of stuff there. And that's what they did with bank paper. They said, hey, we know bank paper. Let's go figure out how we can play with it. But that's what happened. Senator Nelson Aldrich is the guy that called for the meeting.
Okay, so keep moving here. If you want common law, you must have honest measures, and Federal Reserve notes are not honest measures. Gold and silver is honest measures. If you want lawful land, you have to defeat the bail presumptions. Okay, you cannot use Federal Reserve notes. Okay. If you want to be a state citizen instead of being a U.S. citizen slave, then you have to quit doing things that U.S. citizens do and start doing things that state citizens do. If you want to have all the rights and privileges of the land patent, you need to bring it forward. But it's actually depends on your state and your local government officials. You might not necessarily have to bring it forward, but you got to get your land off the tax rolls for sure. And having the land patent is a powerful way or evidence that shows intent to bring it forward to not be on the tax rolls. Real property is that which consists of land and all rights and profits arising from and annexed to the land of a permanent immovable nature. In order to make one's interest in land real estate, it must be an interest not less than the party's life, but because a term of years, even 1,000 years, perpetually renewable, is a mere personal estate. So you see what they're doing. They're differentiating between real property and real estate. Okay?
So an estate
real
for years,
estate,
an estate for years.
real estate is something you have an interest in, like your father's estate, but you don't own. You have an interest in it. That is all.
Until the estate passes to you, but real property is just on its own, solid.
Right. Exactly. So you have, for example, most places have mortgages on it. Okay, that's real estate because the bank really owns it till you pay the mortgage off, and then maybe you have to bring forward the land patent. But
Can you bring forward a land patent? Well, I guess the answer is yes. Bring forward a land patent if you were in a mortgage situation, you ended up paying it off, you were paying your property taxes, and that was what you said with how to do it, with the process of getting another person involved, because you kind of have to, you can't just go own it the way you did, and then all of a sudden bring forward the land patent.
you could. I mean, but I usually what I've done. Well, I'll show you what I've done, and it works. It depends on the corruption, how bad the corruption is, and because it can work, but it depends on. I'll show you some of the stuff I've done, but and then what I'll tell you is the stuff that you have to do if you want to basically make it bulletproof. Okay, but you can have defects in it. I mean, a defect like what I've done is I deeded it from myself to myself. Right? That's one thing I did.
They could challenge that at some point.
Huh?
Could they challenge that at some point?
Well, it's not perfect.
Would you
Well,
change the
I
form
don't
of the
see
deed?
how they could challenge that.
Okay.
But to deed it from yourself to yourself and bring forward all the rights and privileges of the land patent, you could do that. What's that?
Do you change the form of the deed in doing that?
Oh yeah. I make up my own deed. It's my own wording.
Yeah.
You see what I'm saying?
Sure.
And I bring forward all the rights and privileges.
Were you deeding it from the straw man to the living man, or was it living man already?
Well, technically, it's always.
Check out my other videos: Bankster Thieves Playlist, Roman Cult Playlist, Bankrupt Corporate So-Called Governments, Bar Members 1 through 3, Do-It-Yourself How Not to Volunteer for the Selective Service in the Draft, Martial Law is Here, Do-It-Yourself No Income Tax, Do-It-Yourself Free Mail, Do-It-Yourself Kangaroo Courts 1 through 13, Canada Border Pigs Playlist, Bar Members and their Satanic Connections Playlist.
But I'll show you the deed.
You ever do anything with acceptance?
When I
of the
get
deed?
to that point. Huh?
Acceptance of the deed?
What?
Proper acceptance of the deed?
I have a confirmatory instrument that basically does the same thing, except that you're not deeding it in that case.
No,
it's a confirmatory instrument
when
that
you
you file.
attended the deed, it should be accepted, and that's a lot of people fail in that.
Well, yeah, I haven't done that. Okay, but what I do is the best way that I found that works the best is when I buy the land, I buy it under the name of a structure, and then I can put my own wording on the deed and deed it from the structure to me. But I haven't ever accepted it, and maybe that's a defect. You know,
Well, I think it is. With my background in real estate, I think it is. I think it's just like parents patria, where the father, acquiesces, and the child is a ward of the state. So if this were here, the state comes in and says, "Gee, it's not accepted. I'll grab it."
It's open-ended. It's not.
Right.
It's not completed. The
Exactly.
owner didn't show up yet.
That's possible, and so maybe
I'm
you guys
just
could
throwing that out.
maybe you guys could show me something that might want to think about. You know. But so anyways, the bottom line is there's a difference between real estate and real property. That's the purpose of this slide, is to show that there's a difference between real estate and real property, and everything you see out there is about real estate. Real property is everything, is land and everything that's attached to the land. Real estate is real property that you have an interest in, but you do not own it. Estate is the operative word, and estate is something you have an interest in, but you do not own, like your father's estate. Title estates, okay, this is a definition that's taken from Bouvier's Law Dictionary, 1856 edition, so I'm not going to have the whole definition in here because there was several points, but I'm going to talk about some of them. Because, you know, to help expand on different kinds of titles. The title is defined by Lord Coke to be the means whereby the owner of lands hath just possession of his property. This is the definition of title to lands only. And so then number 3 was a title is either good, marketable, doubtful, or bad. Okay, so there's 4 kinds of title. A marketable title is one in which a court of equity considers it to be so clear that it will enforce its acceptance by a purchaser. So, in other words, the banks, you know, a marketable title is one that the banks will loan money on. They got to have marketable title. But as a court of equity has to do with all mortgages are an equitable interest in the title, in the land. You see what I'm saying? So at the bank, so the banks will always insist on what they consider to be marketable title. They do a title search, but they don't do a thorough one. They just do it, you know, back a ways. I think, I don't know how far, but again, they're interested in marketable title. That's all they're interested in, and that's why they make you buy title insurance.
Equity. Could you explain it at all? Is it sort of the value of something, or?
Equity?
Yeah.
Actually, I think I cover that in here. If not, I'm pretty sure I cover that in here. Because equity is the power of the court to basically do anything they want. Okay, the power of equity. The power of equity is the power of the court to, like, bend the law, bend the rules. You see what I'm saying?
That was on the slide yesterday. We talked about it a little bit yesterday.
Yeah, we'll talk about it. I think we talk about it more in here, but if not, I have some slides that we can talk about it. I'm just trying to think of where they were. I think they're in here, though. Anyways, title estates, the doctrine of marketable titles is purely equitable and of modern origin. And so the point being is that, like, a mortgage is equitable. Okay, in other words, mortgages are a fraud. All mortgages are a fraud. But there's whoever holds the mortgages has an equitable interest. And so what happens is when these people go in on a foreclosure, the bank sues them for foreclosure. Well, it's a foregone conclusion, okay? Because there's a doctrine under equity called the clean hands doctrine. In other words, you cannot expect equity. There's maxims of law that talk about it. Equity will not get relief or give relief unless you have clean hands. In other words, you're innocent. You haven't done anything dirty. You see what I'm saying? If you're behind on your payments, then you don't have clean hands by definition. Okay? And the bank, even though the mortgage is a fraud, the bank has clean hands because they created your fake money. They gave it to you. You went out and spent it. You see what I'm saying? And so the bank has clean hands, and they've done everything that they needed to do. And so when the bank sues you over a mortgage, people wonder how come the judge just rules against them all the time. Well, it's because of the clean hands doctrine. Because you have not, if you want to sue a bank over a mortgage, you have to go on the attack. Okay? You got to come across as if you have clean hands, and you got to paint them as the wrongdoers. And you got to show that they're nothing but thieves, okay? And the mortgage is a fraud, and all this other stuff. And so that judge is sitting up there playing stupid, okay? And if you don't tell him the right things, and they do tell him the right things, you lose. That's all it comes down to.
Generally speaking, the one who launches the attack is the winner.
Generally speaking, under equity, that's true.
Right.
But again, it comes down to clean hands.
Right.
Okay, that's really important. Somebody's outside the door.
Do they have clean hands?
I don't know.
Right over there, gonna have a seat for you.
So with people with mortgages,
Good spot.
when they're dealing with the banksters, they don't understand that, they wait till the bank files a suit foreclosure against them, and then they start bringing up, well, this loan's a fraud. They didn't really loan me any money anyways. Well,
Too late.
it's too late, okay, because they don't have clean hands.
Right.
And the bank has brought the lawsuit, and the bank has done everything they were supposed to do. Everybody knows the mortgage is a fraud. Everybody knows that. Everybody knows the banks don't loan money.
Well, that's sort of the symptom of all of our issues. We don't get to it until we're on the downside.
And that's why you lose.
Right.
Just look.
That's
look
why
at the
you
word.
have to be proactive.
Yeah, just look at the word foreclosure. When did the closing take place?
Well, there's
It was before. It was foreclosed. When you were involved at the real estate closing, that's when the foreclosure took place. You entered into that contract then. That's why the word is foreclosed.
And they have
Okay?
power.
Go right there.
I'm sorry,
When you go to real estate closing, that's where the fraud is executed. If you don't raise your objection then,
Well, and
you participated.
really
You're in the game.
the real solution is don't deal with the banksters.
Right, but isn't there a current movement whereby if one goes on the attack, you can basically invalidate the...
You can.
Okay, so
You
has
can.
anybody here done
It's
that personally?
well, there's court cases where they talk about it, where people challenge the existence of the note, okay, and they get away with it, and the court and basically they say, well, there's no note, so the banks don't have anything, okay. But I guarantee you, and I don't know, I've seen some of these court cases, I don't know the particulars. I guarantee you, if they did that, they brought the action on their own before the bank was foreclosing. They probably stayed.
No, I agree.
Okay.
But the point of my question is if it's a foregone conclusion now with the understanding we have, why doesn't anyone with a current valid paid-up mortgage proceed to...
People don't act until they're injured.
No, we did just that. I came up with a strategy to challenge while current, and I found somebody that wanted to do it. But the wife was really not on board, and it was in her name, but we went ahead and did it. And we challenged it, and I told them, open a bank account, and just every month make the payment in there to show that you have the money. It's not about the money, right? And we had them. And then the wife kept, bothering him. And eventually, they didn't even tell me. They went and paid the amount, like it was already $17,000 that they had saved up. And they returned the check. And I said, oh, great, right? And he goes, yeah, but I sent him another check with the next month bank check, which is what they wanted. And
Yeah, they sabotaged themselves.
yeah,
And
It's-
Bill
yeah.
knows a postmaster that paid off a mortgage using administrative procedure twice.
Hey,
And
for
his
me.
wife, the wife sabotaged it.
Oh, yeah.
She went back and she says, no, we didn't do that. I want to still make that mortgage payment, and restarted the contract.
They said our balance of zero.
That's
I
right.
says, oh, no, it's not paid off yet. I'm going to get
You can, this is a neat procedure, but you can file bankruptcy. And on the bankruptcy asset list, put the loan as your asset.
adversary.
Because every loan in the banking accounting is on the liability side of the bank's ledger. Because it's yours, not theirs. You own it, they owe it, and the accounting proves it. So what you do is you get the bankruptcy trustee fighting with the bank. One rat chewing up another rat. Depending on the bankruptcy trustee, they may choke, but that's reality. Bring forward the accounting. Get a certified public accountant that knows the story with his documentation, and the bank accountant. Because they have to follow.
I've been reading about a clean way, if you have a current paid-up mortgage, apparently if you can just go directly to invalidating the mortgage, and because, through the signature, there
You
was
can.
never a loan.
You can.
So my question was, has anybody here done it? You almost did it. It wasn't because of the reason. So I'm just saying that's out there.
I'm sure people have, okay, but let's face it, they don't advertise that kind of stuff.
Who is they?
The bank.
The New World Order crowd,
No, but the
the
people
deep
who have
state.
done it are advertising, that's how I know about it.
No, there's some people that have done it
Yeah,
Yeah.
successfully.
So I can't understand if it's that straightforward. I guess it's just all about education, fear.
Right.
Oh, fear
Right.
is a big problem. With
education and
Who
fear.
wants to be out?
Most people don't know that the banks don't loan money.
Exactly.
They think the banks actually loan money, and they don't.
Right.
They don't.
Right.
It's in their own documents.
Right.
Banks do not loan money.
Everybody beats you down. This wife was worried that her neighbor, they were going to be embarrassed, going through theirs, and then there's going to be a foreclosure, and what's the neighbor's going to think, and all this stuff.
Keeping up with the Joneses, huh? They don't know the Joneses are bankrupt too.
So, anyways,
I ran into actually out of Texas, there's a company that you can hire that will audit the bank process for you, and they'll go back from the day you were at your closing table,
right.
and they'll follow the process for you, and they'll send you every little bit of what you need to go to the court and show them that the bank broke every rule that they're supposed to follow the minute they walked away from the closing table, and you can do what you want. He said the only time it doesn't work is when the person who goes in there gives information they weren't supposed to give. That's the only time they said it gets messed up. They have
right. Forensic accountants. That must be in a forensic accountant, right?
Yes.
Yeah.
Yeah, they're a team that just will look into it for you. They don't come and do it.
You can actually do it yourself. Just go to the MERS website, because MERS does all the monetizing. If your loan is it's MERS.
It's a MERS.
It stands for
Mortgage Electronic Registry Service.
Right. And if your note is there, then it's monetized. Because that's all they do.
Yeah. So, anyways, the important thing is you have to understand the nature of equity, and so his question about equity is a good question because most people do not understand how equity works, and also the fact that when you're under martial law, it eliminates common law, and then equity can do anything it wants, and so it's contingent upon having a judge that wants to be a judge too, because some of them are just can do anything. They all know they can do anything they want. If he wants to do the right thing, then they will. But some of them are just crooks. You know what I mean?
And see, part of the problem there is conflict of interest, because most judges somewhere, somehow, are tied to investments, tied to mortgage-backed securities.
Well, and that's true.
So you can, get them off the bench on that issue.
That's true.
Until you find someone who's not, and that's difficult.
Well, and you never know until you get them.
Right.
You can't chop judges.
No, but there's so much tied to mortgage-backed securities. That's why they don't let it go. You can play with credit cards or whatever, but when you're dealing with the secondary mortgage market and follow that and trace it where they go, they can't let you off that treadmill because mom and pop's retirement account and Uncle Sally and Uncle Sally, Aunt Sally, they're all tied to that.
Sure about
the whole system would collapse on its own weight.
There are some recent cases where the courts have determined that if the banks do not have the wet ink signature note, they don't have standing to bring a foreclosure.
Well, and that's fine, but again, if you're going to bring up that issue, you've got to bring it up at the right time, because if you don't, then equity says you don't have clean hands.
Right.
I forget what the site is. UCC identifies that if you're going to make a payment, they have to produce the wet ink signature on the note. If they can't produce that, they sold it. They don't have it.
Right.
Okay, and if they sold it, where's the set-off for you? And that's the issue. They have to produce that. And I forget what the site is. I had it,
Okay.
I don't have the particulars, but I think it was Jerome Daly, River Credit decision, where the judge showed that there was no money lent, but
Credit
then
River.
the judge was killed 6 months later.
Right, that's Credit River decision.
Yeah.
Credit River Justice of the Peace Act.
Right.
The document you want to get from the Federal Reserve, I've got some hard copies. They don't have hard copies anymore. It's Modern Money Mechanics. It's downloadable off the site. But read the first third of that book with a magnifying glass. Just to give you the accounting.
It's about 20 pages. Now, the ones that you get, you have to look around because some of the ones you get have pages missing. So you got to find the one that's complete.
Actually, the full document's 40 pages.
How many?
40.
Well, whatever it is, but you got to make sure all the pages are there. Right. I use it in my video. I got a video called "No Such Thing as a Bank Loan," and so it's in there, and I show you the actual document, and then I show you the text. But anyway, so let's keep going. The doctrine of marketable titles is purely equitable and of modern origin. At law, every title not bad is marketable. So that's all they're concerned about, is if it's not bad. And then at common law, doubtful titles are unknown. There, every title must either be good or bad. So at common law, it's either good or bad title. And authorities hold that to render a title marketable is not only necessary that it should be free from reasonable doubt. In other words, that a purchaser is not entitled to demand a title absolutely free from every possible suspicion. And that's true. That they do a title search, but it's not a very thorough one. And I don't know how much. Every bank is probably going to be different, but as long as it's what they consider a marketable title, they're gonna fund the loan. See what I'm saying? The so-called loan.
Right, they're not funding it, right?
Yeah, it's a so-called loan.
They say they're funding.
It's a fake loan.
It's a fake.
Anyways, a bad title is one which conveys no property to a purchaser of an estate. A title to real estate is acquired by two methods, namely by descent and by purchase. And so that's why his position is so powerful, because it's been passed on in his family. And that's I tell you, he makes a good criminal complaint. I bet you he could have some people in jail over the stuff they're doing to him. But anyways, these deeds include the ones as follows: a warranty deed, a quitclaim deed, a sheriff's deed, a trustee's deed, a judicial deed, a tax deed, a will, or any other instrument which purportedly conveys the title. Each of these documents state that it conveys the ownership to the land. Each of these, however, is actually a color of title. Wow. So it's a fiction, okay? And in fact, even the patent, okay? We're going to see some stuff here. Color means an appearance, a semblance, a smulcrum is distinguished from that which is real, a prima facie or apparent right, hence a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise or a pretext. It's a fraud. So they give you, I've seen court cases that say we have to have the appearance of justice. Well, gee, that sounds like the color of justice. That sounds like a fraud. Then that's all you ever get in these courts, okay? Because they're not Article 3 courts. There's no Article 3 courts.
Has anybody here ever been in an Article 3 court? No.
Well, I doubt it. I mean, I thought I might have been in one sometimes, but now that I know what I know I have never been in an Article 3 court. And I suspect there hasn't been an Article 3 court since probably about 1861.
So why wouldn't Texas, which has now gotten all of the counties basically repopulated, why wouldn't they have what they need to have an Article 3 court? Is because there's no Article 3 judge?
Well, in Texas, Article 3 doesn't apply.
Because of the Republic?
Yeah. This is a Republic of Texas, that's right. Texas is under a military occupation, has been since the Civil War, and before the Civil War, it was never really part of the United States. There's actually people that have done research on that. What they did is Texas did any nation joins another nation, they have to do a treaty of annexation, okay? And Texas actually did do a treaty of annexation, and they sent it to the U.S. Senate for approval and adoption, okay? Well, the U.S. Senate did not approve it or adopt it. They shelved it, okay? They didn't act on it. What they did was they did a House Joint Resolution, okay? That's not an approval and adoption of a treaty of annexation. And so Texas has never been part of the United States. And there's actually court cases that talk about it. There's the Republic of Texas brought an action in the 90s to the Texas Supreme Court, and the Texas Supreme Court dismissed it for lack of jurisdiction. Then they took the action to the U.S. Supreme Court, and they dismissed it there for lack of jurisdiction. And then they took the action to the World Court, and they dismissed it there for lack of jurisdiction. Well, you understand what they're saying.
You're on your own, you never were, you're a country.
Right.
You're on your own.
The United States,
Meaning Texas.
there's court cases that say there's two federal governments. In Downs versus Bidwell, it says there's two federal governments. There's one that operates within the Constitution and the other one that does not. And the same thing is happening in Texas. Okay, so when they take it to the Texas Supreme Court, the state of Texas is a subsidiary of this unconstitutional corporation in the District of Columbia, right? And the World Court is a court that's set up to administrate disputes between these unconstitutional corporations. It's in Chisholm versus Georgia, which was in 1798 or something like that. The Supreme Court said that there are no nations on the planet except for maybe United States of America. He said all the rest of them are societies. Said all the rest of them are societies, and that was in the 1700s. You think anything's changed now? Well, it might have. When Russia went and had that, remember back in the 90s when they went and besieged the White House, and there was that kind of revolution that went on in Russia, that after the wall fell with the Soviet Union, and then Yeltsin was in power, and then the White House was besieged, and there was kind of like a little mini revolution. And I think that maybe Russia might be a de jure nation now.
The White House or the Kremlin?
They call it the White House in
the
Russia.
White House? I didn't know that.
Yeah. Well, it might be where the president lives or something. I don't know, but they call it the White House in Russia too. But
are you saying that Russia is a sovereign?
A real nation might be, yeah, and I think Ukraine might be too. But
no, Ukraine is independent.
Well, I didn't say they weren't independent.
From Russia.
I didn't say that.
Does mean sovereign?
Yeah, I understand that.
Yeah.
Ukraine, and that's what I said, and Russia might be a real sovereign nation. Whereas, because I went to Ukraine, and it's interesting when you travel to these foreign countries. I've been all over the world. I've been to Europe dozens of times, in and out of France, Paris, all over Europe, Africa. Anyways, when I went to Ukraine, they stamped my passport with a red stamp. Okay, red means de jure. Red is lawful. And when you come to U.S., you get a blue or a black one.
In the sea still.
Right, exactly.
Wow.
Okay. Well, I went to Ukraine. I got a red one, and I passed through Russia a couple times, and it was just at the airport, but they stamped my passport, and it was a red stamp too. And I think that what happened was, I think Putin is a pretty smart guy, and I think that the powers that be knew about the banksters, and they wanted to get them out of there. And so the way you do that is with a revolution of some sort, okay? And so they went and besieged the White House. Maybe some generals went and decided to, you know what I mean? And they had a little mock battle, enough to say that, well, this other government's history now. You see what I'm saying? And so now we're going to start a real one up again, That's my guess.
Russia actually paid the debt of the former Soviet Union, which removed any encumbrance.
Well, that's possible. That's possible. Russia gets a lot of money from their oil, so they might have just paid off their debts. And matter of fact, I've heard that they have paid off their debts.
Yep.
And so that could be part of it too. I don't know. But all I know is that when I went there, they put red stamps in my passport, and nowhere else have I seen red stamps. It's usually black or blue, and all of that has symbolism. It's all important. Like the post office, for example. A lot of the post offices you go to put a red stamp on your mail. you know, when they do the,
Meter stand?
Yeah.
Cancellation.
no, the cancelization, yeah, right, right? That's significant, okay? They don't do that by mistake. You know, when the clerk stamps, you know what I mean? Like if you send a registered letter, the clerk will stamp all around. You see what I'm saying? Those are
So
red.
that's basically saying that the articles, the post office was first, not the postal service.
The post office was first, and it's never been bankrupt.
Right, so that clerk is still saying, we're legitimately still
We're
here."
lawful, we're de jure. That's right.
They don't know that.
I mailed a letter with 2 cents, and this is at the beginning of the game. He put a Post-it note on top of the receiving address, and then printed a little stamp in there, return for delivery, or return for postage. But he didn't even print it on my letter. He printed it on the Post-it note, and he pasted it on. They're afraid of me. No, another one. U.S. citizen must pay full postage. Well, who says I'm a U.S. citizen?
No joke, huh? Yeah, no joke.
When, in reference to Article 3 courts, there are only 2 in the United States. 2 established and ordained, one in Hawaii and one in D.C. The only problem with the one in Hawaii is they never appointed any judges, so the only real Article 3 court is in D.C.
Isn't there one in Pennsylvania too, though?
Well, I don't know about an Article 3 court. If you read the in Title 28 under the district courts, and you read the historical notes from 1948, that's where you could read about the Article 3 court.
So which court in D.C. is the Article 3 court?
I don't know the exact address, but
Is it a district court? Is it what? Do you know?
I would think it is the district court.
U.S. District Court?
Yeah. I do believe. Just a district court of the United States.
Well, actually, the Informer...
There is a
on one of
U.S.
the
District
calls
Court
about the
in
address.
D.C.
I'm not sure if it's one. The Informer, I don't know if anybody's ever studied him. It's worth listening to him on YouTube. He's a wealth of information. I think at one point he did give out the real address for the real Article 3 court in D.C., but...
Could it be housed inside the Supreme Court, like you were saying before?
Who's the person referenced?
The Informer.
Oh, the
He was
Informer,
a
yeah.
researcher.
Yeah.
Right, I remember him.
And so...
Isn't he passed away or something like that?
Probably.
Anyways, colorable means that which is in appearance only and not in reality what it purports to be, hence counterfeit, feigned, having the appearance of truth. In other words, it's a fraud. Color of law means the appearance or semblance without the substance of legal right. Misuse of power possessed by virtue of state law and made possible only because wrongdoers clothed with authority of state is action taken under color of law. When we say a person has color of title, whatever may be the meaning of the phrase, we express the idea, at least, that act has been previously done by which some title, good or bad, to a parcel of land of definite extent has been conveyed to him. Where the complainant seems to have relied upon the tax deed as conveying to him the fee, and to sustain such a bill, it was incumbent of him to show that all the requirements of the law had been complied with. So, think about it. What they're saying is somebody bought some land based on a tax deed, and whoever they thought they bought the land from, they didn't. You know, that's Hulls versus Bunton. I would say Hulls was where the complainant seems to have relied on the tax deed, so Bunton was in possession of the land, Hulls bought it, and it went to court, and Hulls lost. Because the burden's on the buyer to prove that you own something. Buyer beware, caveat emptor, right?
Well, would that be fraud?
Or it would be on the part of the taxing authority.
Right.
You'd sue their butt off.
Right.
Absolutely.
It's like selling the Brooklyn Bridge. I mean, it's still fraud.
Yeah, absolutely.
You couldn't sell it.
Absolutely. Land titles come in various forms. There's a general warranty deed, special warranty deed, sheriff's deed, judicial deed, quitclaim deed, land patent. So we're going to talk about all these. A general warranty deed is where the seller warrants the title to be free of all liens and encumbrances. A general warranty deed is what is generally received in order to get a mortgage before a bank will authorize the mortgage, and it's considered marketable title. A special warranty deed is a deed where the seller will warrant the land free of all liens and encumbrances with some reservations, usually as a result of a foreclosure or tax sale. A special warranty deed is considered marketable title. Sheriff's deed is when the sheriff sells a piece of real property, could be from a foreclosure or tax sale or something like that, and it's considered marketable title. A judicial deed is considered marketable title. Quitclaim deed essentially says that the seller transfers his interest in the piece of real property. The property sold because of a tax sale can be transferred by quitclaim deed. A lot of taxing authorities sell the land based on a quitclaim deed. They'll give you a quitclaim deed, and because that's actually the only legitimate way that they could do it, because everything they do is a fraud. And a quitclaim deed can transfer title just as effectively as a general warranty deed. A lot of farmers and people like that, they will just quitclaim the deed to their son, right? The West 40 or something like that. You see what I'm saying? And so, nothing wrong with that. It works fine. Possession's 9/10 of the law. And so, a quitclaim deed can transfer title just as effectively as a general warranty deed, but a quitclaim deed can also transfer nothing. Quitclaim deed is a deed of conveyance offered by way of release that is intended to pass a title, interest, or claim which the grantor may have in the premises. So that's it. I sell you my interest in this property. I may not have an interest, but what interest I have, I'll sell you.
If any.
If any.
And I have a Brooklyn Bridge if you'd like.
That's how they do the Brooklyn Bridge. It's always how it's done. A patent to land issued by the United States on authority of law is the highest evidence of title, something upon which its holder can rely for peace and security in his possession. It is conclusive evidence of title against the United States and all the world. Nothing but a patent passes a perfect and consummate title. A patent issued by the government of the United States is legal and conclusive evidence of title to the land described therein. No equitable interest, however strong, to land described in such a patent can prevail at law against the patent. A mortgage is an equitable interest. So that's one thing you can do. You can hurt the bankers. I've seen people do it. They bring forward the land patent, like this lady that I was helping her in Texas, where she had taken her property off the tax rolls, and she had been in the house for 10 years, but they're trying to foreclose on her, after she hadn't been making payments or anything for 10 years. And so I told her, bring forward the land patent. That'll hurt them, I'll tell you. You can, essentially what happens is, if you have the land patent, you own the land. The bank might own the house, so they might be able to come and get the house, but they better not trespass.
How did that end up?
I don't know yet. Well, it's fairly recent.
So
But
again, that goes back to my question. Can one bring forward a land patent while there are other encumbrances?
well, sure you can. There's nothing stopping you from doing it, but the banksters are thieves. And so, they don't loan money. They don't do any of the stuff they say they do. And if you deal with them, it's like a contract with the devil. And so they're going to try and steal it anyways. You see what I'm saying?
Yes, I do.
I mean, they sold a house on me out from underneath the banksters, and by the banksters. You see what I'm saying? I brought forward the land patent, but I can tell you that the guy that bought the house can sell it. Okay, the title was clouded. It was clouded really bad, and he couldn't sell it. He got a deed from the liars, but I guarantee you that he couldn't. He's renting it.
From
Not renting it from anybody. He's renting it out.
Renting it out.
I can't sell it. So you have the land patent, but you don't have possession.
Yeah, essentially.
So at some point, will you?
If I can find a judge that wants to be a judge, then that's fine. Yeah, at some point. Hopefully, we'll see.
Gotcha.
Anyways.
Now that statement says patent issued by the government of the United States. There's other patents in this country that have been issued from other sources, King's grants.
That's true.
Or whatever.
Well, that's equivalent. That's equivalent to the government. You get.
Not the government of the United States. Not if it was, executed that way. Matter of fact, a lot of the colonial states were generated that way too.
I understand, but they're crown grants,
Right.
and the crown grant should be just as good as a government patent.
I fully agree, but I was just curious, what you.
I mean, I've seen crown grants. I've got crown grants. We'll see some in this presentation, and They're just as good as the government of the United States. All it is really is a letters patent, okay? And they use letters patent for a lot of things. Land is only one of them. They use them for other things, for commissions, for all sorts of things. And so it's just a letters patent is what it is.
How did you bring forward the land patent if you didn't have any possession or?
I did at the time.
Oh, you did at the time. Okay.
And actually, really, if you really understand the law, I could bring forward the land. Do you have the land patent on this?
Not yet.
Well, I could probably bring forward the land patent on this and take it from you.
So that's my question.
Technically, yes, because you really don't own it. Technically, yes.
So to bring forward a land patent, don't you have to prove anything?
Well, you're the one that's in possession, right? You have a piece of paper saying that you thought you bought it. You can, I mean, didn't you think you were getting the land patent or all the rights and privileges? And so then, I don't know, whenever I buy land, that's what I think I'm getting.
You just said technically. Like, you're not a squatter, you haven't been on the land, therefore how can one bring forward a land patent?
I think that the simplicity of the land patent is you do some research and show the linking of all the titles, and then you publicly say, if anybody has a claim, bring it forward.
Yeah, I just record it.
Yeah.
And I mean, if you want to run the newspaper ads, you can do that stuff, but I think that's expensive and a waste of time.
But the point is, you give them a window to speak, and if they don't speak, then it's done.
But that's commercial. Okay, if you own it, who's gonna have a claim?
See, that's what the title insurance.
That's all commercial.
That's what the title insurance and the warranty deeds are for, because you warrant the marketable title.
Yeah.
And then you got a third party insurer that will defend that. Okay. And that's what the title insurance companies do. Basically, they're just lawyers that'll step up to the plate and defend it, But now the land patent would invalidate a warranty deed in the chain of title, right?
It will.
But you just got to go back there and assert the prior claim.
But it doesn't matter, because once you have the land patent, it trumps it all.
That's what I'm saying. That's exactly
And so
correct.
it means nothing.
Right.
And it's the title insurance too. I've had people bring forward the land patent, and the title companies will tell them, "You'll never get title insurance on that land." Well, yeah, that's right. Because think about it. Okay, insurance companies cannot commit fraud. Okay, you have a superior title to anything that's out there when you bring forward the land patent. For them to insure it is to insure something that doesn't need to be insured.
Yeah.
Right.
So that's a fraud for them. They cannot commit fraud. And so you got to have an insurable interest, right?
Exactly.
And it's not an insurable interest. They can't insure that because it trumps everything.
Right.
Can only a living man or woman bring forward a land patent?
No, anybody can, but they're still going to try and tax it as if it's owned by a trust because or a structure, because that falls under the definition. Again, these people were brain dead idiots. And they see in Title 15, United States Code, Section 44, that it includes any trusts and stuff like that. You see what I'm saying?
I think the problem that I had was that the county recorder would never take my deed off of my land. Having given them the land patent, they would never take it off their register. So, so they thought it was available for auction, etc. They were supposed to remove it from their,
build a case against them.
Yeah.
Criminal complaint. That's what I'd be doing.
Right.
You build a case against them and you file a criminal complaint, and then they get the FBI coming to visit them, and all of a sudden everything changes.
Can a land patent be brought forward in, say, 3 siblings together? Or does it have to be one person?
I don't see why you couldn't do it. But again, do 3 siblings own the land? Are they owning it? Well, see, you got to understand, first of all, that when they ask you, when you buy land, okay, they want to know if you want tenants in common or joint tenants, right? Well, that's all for tenants, right? That's for renters. That's why it's called tenants.
I understand.
Right. So, I'm probably the way I would do it is I would divide it up, and one guy brings forward the land. See, what you do, first of all, you got to understand. The land patent on this property right here probably is for like 160 acres, right? It's way more than just this property. And so when you bring forward the land patent, you bring forward all the rights and privileges associated with the land patent for this piece of property only. And that's why it's good to get a meets and bounds legal description, but again, that's not fatal. But it's better to have a meets and bounds legal description because that's common law. But you only bring forward the rights and privileges of the land patent for this piece of property, which is a small part of the real land patent. So if you and your two sisters or whatever wanted to do it, then it's probably better to like split it up somehow. You know what I mean?
Well, they could do the three names.
You could.
As owners in the entirety.
Yeah. But then what happens if someone dies? There's no such thing as tenants in commons or joint tenants. I mean, that would create a lot of controversy.
Inheritance rights.
Huh?
There would be inheritance rights.
There would be, yeah.
Have to split
But
it up.
how? You know, you'd have to force you to sell it, probably.
Sell it, and then the land patent would be the strong, whoever purchased it would inherit that land patent benefit.
Could, if you conveyed the land patent benefit, if whoever bought it paid Federal Reserve notes with it, it would just go back to the way it was, right?
Yeah, they'd have to bring the patent forward to them.
Right. And they have to pay in gold and silver. Right? Or you could give it to them.
Right. Yeah, there's nothing
That
stopping
just
you.
maintains the integrity of
It
the
could
land
be a
patent.
backroom deal, and you just put down that I convey this land for 21. I'd always put at least 21 pieces of silver. But convey this. I convey this land together with all the rights and privileges of the original land patent to my sister for 21 pieces of silver and other good and valuable consideration. See what I'm saying? The stuff that's on there, 21, I'd specify, I'd say 21 Silver Eagle coins with a face value of $1 each, something like that. See what I'm saying? For a total of $21 in lawful money. That's what I would probably say. I'd spell it out like that. So then some bail priest can't say, well, looks like they got some commercial paper there. You know what I mean?
But the cleanest way would be just a land patent in the name of one person.
Yeah.
Yes.
Yeah. And there's
But not person, actually.
Yeah, you got
one man.
One man.
And a woman, it's W-O in brackets, man. Okay, it's not female, because that's statutory. So it's a woman. You see what I'm saying? W-O in brackets, man.
Well, that's the construction in Webster's original dictionary.
Is that right?
Yeah, woman is a contraction of two words, woman, man.
Oh, is that right?
And it's identified.
That makes sense.
Webster's.
That makes sense.
You won't find that in the newer dictionary.
Because we're all man, the species man.
Mankind.
But you can't use female, because that's statutory. That's one of the slaves. Anyways, okay.
Thank you.
A patent is the highest evidence of title and is conclusive against the government in all claiming under junior patents or titles, until it is set aside or annulled by some judicial tribunal. Issuance of a government patent granting title to land is the most accredited type of conveyance known to our law. A patent is intended to quiet title to and secure the enjoyment of the land for the patentees and their successors. Thus, as a quit-claim deed, a land patent conveys whatever interest the government has in the soil and the land. Well, think about that for a minute.
Well, you're going back to First Nations.
Exactly.
You know,
that's what I was doing in Canada.
Right.
Is I was getting the First Nations to grant land, to grant people crown land, eh?
Right.
And I'm sure they were happy about that.
Yeah, 'cause that's under Lex Regis.
Yeah.
You know?
Exactly. Exactly. As we have noted in connection with the patent by the United States, the patent effect is the same as though the United States had executed a quitclaim deed. A patent operates as a deed of the government. As a deed, its operation is that of a quitclaim. It passes only the title the government has on the date of the patent. It's well established that most of the land in this country was originally stolen by the government. Matter of fact, in Canada, there's court cases that talk about how the government has to settle Indian land claims. And what they're essentially saying is the government stole the land.
Which could be why the deeds that Manhattan was bought, the island of Manhattan was bought, that was a deal.
Yeah, that's right.
That was a real deal.
Well, it was wampum, though. That was their way of money.
See, the issue was, you know, the Europeans had land use and land control and possession of land. The First Nations used the land but didn't have that possessory mindset.
That's
They
true.
blended more with nature.
That's true.
You know?
And
so that
it was a
concept
common
that
right,
the Europeans brought over was foreign to their thinking. I'll give you a couple beads. I'm good with the beads. You got that? Sure, take it.
They were nomads anyway. They moved to different seasons, they moved to different places, so they're not tied to the land.
Yeah, and that's what makes Rhode Island totally different, because they were not nomadic, you know, and that's why Roger Williams acquired Rhode Island by deed. And the Indians secured some land that they didn't deed to Roger Williams. They still got it. I've talked to the chief, they don't know what to do or how to process that. It's sad.
But when our government came, they conceded that land is either acquired by conquest or by purchase. And, you know, the conquest they consider to be, you know.
Right.
Most of it originally was by purchase, though.
No, you take Louisiana Purchase, who conquered it? The French came in, right? And then you bought it from the French. You know, you did the deed and we just get it for you, you know. But I mean, again, it's all Lex Regis. It's a claim of right of kings.
A patent of the United States as a deed, its operation is that of a quitclaim, or rather of a conveyance of such interest as the United States possessed in the land. A land patent's the highest and best title, but at the same time it's a quitclaim deed. If a land patent is a colorable title, then what would be true allodial title? First Nations patent. There is nothing here requiring a deed to establish a color of title, and under the former decisions of this court, color of title may exist without a deed. Well, think about it. Squatters' rights, right?
Yes.
The courts have ruled that the government has to settle land claims of the original people. They're essentially saying the government stole their land. There's a Canadian patent.
Are the Canadian patents different than the...
They're basically the same.
Yeah.
It's in a box, but the U.S. ones, if you notice on that one, I think it's in a box too.
Oh, I didn't see that.
Maybe it wasn't.
The one signed by Wilson there?
Yeah, maybe it wasn't in a box.
What's the significance of it being in a box?
There's nothing there.
Okay.
Style manual.
Footer rule.
All right.
It says, this is the Calgary and Edmonton Land Company. It's hard to read. Thank you. Wonder if I got one here. I don't think I do. This here is a Texas land patent. You get these from the Texas Land Commissioner for $5, certified. There's the certification. This is a certified copy of the original Texas land patent, a Sharp-Whitley patent.
Did they find the geographic limits of that?
It's hard to read, and in fact it's in Spanish.
But the price was good.
Here's this one that I was telling you that this is the one that I bought. That's this Beechwood Estates. I was telling you that's near Corsicana in Texas, that they keep harassing me. This one here, I used their legal title. In other words, it says Beechwood Estates, Section E, Lot 3. Okay, so I'm using their, in the matrix, sort of legal description. It's not meets and bounds. It's not fatal, though. And, but so this is one that
You keep saying it's not fatal. There's something further you should do, or how do you?
Well, ideally, it would be a meets and bounds legal description. This is one I sent.
I thought, in fact, they wanted range and township and all that.
Depends on the state.
Well, that's a meets and bounds legal description.
Oh, is it? Because I could never find any of those in my area.
Go to the.
No, I thought meets and bounds were just like 40 degrees, 120 feet, etc.
Typically it is, but you know, you can still use the term.
Here's
Out
one.
west, the section, range, and township, so it's a lot easier to find the aliquot part of the original, grant,
Well,
back
for
in
West
the
Virginia, I've
colonial
never been
states.
able to find township or range or whatnot. I'm not sure if they ever existed, but I think they did.
You're in West Virginia?
No.
Yeah, see, West Virginia goes back to part of Virginia, so
Right.
it was a spin-off of that
I
whole
read it, I don't know what
extended
it's
western expanse of Virginia. So you'd actually, for you in West Virginia, you'd probably have to go back to Virginia records.
Well, I'm going back 250 years, but,
When was West Virginia established?
1863.
Yeah, I would think you'd probably have to go back to Virginia records for you.
Well, I was told only I had to go back to 1910, but I went back to 1790 something.
Yeah. See, that
Recent-
property I got in New Hampshire is in the National Forest, but it was built 100 years before the National Forest.
This is one here that I bought from someone, and they sent me an affidavit of property value, but I sent it to them without the affidavit of property value. Sent it to the recorder. And so this one's got lots of defects in it, but it still worked because it was taken off the tax rolls. Because I sent it, in Arizona you have to send an affidavit of property value, and what I do is I send it by registered mail without the affidavit of property value, and then the county recorder sends it back saying, we've put this in a special file. You'll see this is their sheet right on the front. We put this in a special file until you send us the affidavit of property value. You just never send it to them. So it's in the non-taxpaying file. See what I'm saying?
That is a deed or a patent?
That's a deed.
Okay.
Just a deed.
Just a deed.
So what I'm saying is that's why it's not a big deal. Well, it's not that big of a deal if there's defects. This is one that I did.
What's not that big of a deal if there's defects? Bringing forward a patent or not paying the tax?
Bringing forward the patent. In other words, if you use their legal description that's technically in the matrix, that's a defect. And it's better to have it perfect, but it's not fatal.
Right. So you're not redefining it meets and bounds, you're just using what you have.
Yeah. This is one I did in Texas, in Hudspeth County. There's the land patent, and here's the deed that I did. And I'm using the Lot 10 of Golden Hills Estate in Section 37, Block 68, Township Number 1 of the Texas and Pacific Railway grant known as... So this is almost meets and bounds, except it's Lot 10 of the Golden Hills Estates. See what I'm saying? But then it goes into Section, Township, and Range.
The point of bringing forward the land patent is to increase the security.
Yeah, basically, yeah.
Because you're no longer tenant, you're the king.
That's right.
Gotcha. And everybody has the right to do that, but they have to do it.
Yeah, right.
That's all.
Yeah, that's right. Say the words.
Say the word.
Say the words. This one here in Texas, they started, notice how they, I always tell them zip code exempt. They sent it to me zip code exempt. With no zip code, got to me just fine. It was before I was using Ted's mill procedure, but I had a lot of it that I was already using. Some of it, the general post office stuff, and that I didn't use at this time. But they sent it exactly the way I told them to send it. and got to me fine. And I think, let's see, how big a piece of property is this one? I think this is, I got two pieces of property out there. I got one that's 10 acres and one that's 20. And I'm not sure. One of them, what happened was they were harassing me for property taxes, and I had to file a criminal complaint against them, and I'm not sure if this is the one. Yeah, it's hard to tell.
So let's say you have a 10-acre piece. It does it. You're not. It's the land patent's forward. It's on off the tax rolls, and it's not got a property classification. And you want to do something with it to develop it or whatever. What happens at that stage? Regarding the authorities, quote unquote.
Well, you have to understand that licensed contractors can only do stuff with a permit. But if they're not licensed, then you can do whatever you want.
As long as you don't harm anybody else.
You can't hire anybody that's got a license.
Nice.
Okay, that's all. Just don't hire anybody that's got a license and just go ahead and do it. You don't need their permission.
Or if they want to do it in their private capacity without the license, that's fine too, right?
Yeah, that's probably true. Mm-hmm. Yep.
The only
So you disclose, you tell them that I want you here, I want you to build it, I want you to build it to code, but I don't want you here under your license.
Okay, so that's so you are still abiding by code.
Well, I would want it by code just as a matter of if you ever decide you want to sell it, then it's going to be like everybody else, and it's probably going to be good quality construction. But the city's not going to come out and inspect it. You're going to have to be on top of it. You see what I'm saying?
You don't want it to fall down.
There's a few things you got to worry about with that. Is when it comes to utilities, they may not connect utilities unless it's inspected. So you have to kind of be cautious of that.
If you need an occupancy permit.
And you also don't want to violate anybody else's rights.
So, I guess it depends on where you're doing it. Most of my land is kind of out in the country. I'm a kind of country guy, And so I would, if you're concerned about that kind of stuff, then, you might want to jump through the hoops. I guess it's up to you.
I'm just trying to understand how to have all the benefits of, say, living close to people with utilities and services, and now you had to grant them an easement or whatever, and at what point does that go ahead and create a problem for your land patent?
Well, it really wouldn't. I mean, you still have the land patent. You see what I'm saying? But, at what point, the question you have to ask yourself is, at what point do you want to accept their rules and regulations? Get off my property.
Correct me if I'm wrong, but the land patent affects the land, not the structure on the land.
Probably, but again, there's a trespassing issue.
Right.
So you put up no trespassing signs. You tell them stay off my property.
So city officials, quote unquote, couldn't necessarily come on the land for any reason unless you gave them permission.
Oh, of course not. Of course not.
The only problem is the electric company won't tie into the house unless they have certification from the electrical inspector and all these other things.
Good time to go solar.
You got to worry about
Go solar, that's right.
Yeah.
Free energy.
Go off grid.
Put a generator.
Now we don't need a smart meter.
Yeah, really. Those are all things to be aware of, at least, that there's a potential.
How in the real world it works.
Right, right. Mm-hmm.
And at what point, like, let's say, for example, typically this is in a R2 zone, for example, according to their rules. Well, what if you wanted to build something that was 8 units, and it wasn't allowable under their rules? But am I out of their rules because of the land patent? Even though I'm in a corporation.
You would be, but you're going to have to probably have a little battle there.
Oh, no, you think?
But I could tell you that Peter, remember Peter?
Yeah.
He's built, his father is a general contractor in Canada, and you can imagine what Canada's like as far as rules and regulations and crap. And He's done several places, never got a building permit. He bought a house in Austin that's in a nice neighborhood, but it was a crack house, so it was basically, you know, destroyed. He's rebuilding the place, and he's not getting permits, and the city keeps coming by pestering him, and he tells them to get lost.
Nice.
You see what I'm saying?
That's in a city. That's in a city
That's in the
corporation.
city, Austin. That's right.
Wow.
So again,
And he does it. He's got the ability to do that because of what?
well, he's not licensed. He does everything himself, first of all.
No, but I mean, as far as the underlying, is he on the tax rolls?
He wants to get off of that.
But so I'm
Yeah, he's
wondering
on it.
why he can't. Well, if he's on the tax rolls, why they then, by right, don't have the right to?
Well, they don't really. Okay, it's all, they have to get your consent, no matter what. It's always by consent, no
I
matter
don't
what.
get permits for anything I do either.
And so he just tells them, puts up no trespassing signs and tells them to get off his land.
Right. And if not, then he files a
He
criminal.
files, I told him, I said that, he said they keep coming on it, and I said, well, go to the city cops and
Notice
file a
and demand.
complaint.
Notice and demand.
No, send a notice and demand,
Initially.
file a criminal
By
complaint
name,
for
and
trespassing.
then- Okay.
Vid.me shut down on the 15th of December, and my YouTube channel called Sovereignty International has been terminated. YouTube went and changed the rules, so I said screw them. I made all the exclusive content is available on my website. I actually uploaded the videos to my channel, my other channel, the one that's got, the big one has got currently about 14,000 subscribers, Sovereign Living. And so I had uploaded those videos to there and made them private. And so the exclusive content is available on my website, but you'll need a Google account to set up access. I have 2 subscription levels, and I accept cryptocurrencies. My basic subscription level is $2.99 a month or $19.99 a year for the videos only. My the platinum subscription level is $4.99 a month or $39.99 a year for the videos plus unlimited consultations. Now, there is a limit as to what I can do as far as consultations are concerned. I am not a liar. Well, actually an attorney. No, actually a liar. But I can tell you what I would do in a certain circumstance and where to find the forms. That's the limit of what I can do as far as consultations are concerned. The only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit, but I cannot fight all the battles. I need more people doing it and being on point, and that's why I do this. Even if you want to make it a donation, it's a modest donation, there's no doubt about it, but everybody, a lot of people chipping in a small donation, it adds up pretty fast. So either way you want to do it is fine with me. I'm currently publishing a video actually about every 2 weeks, and I don't see that changing anytime soon. I've kind of run out of topics, but I do have some ideas on some stuff. I might go to 1 a week. We'll see how it goes. Actually, I think it will go to 1 a week because I'm starting to do some private information shares. I'm holding some meetings, some regular meetings in the DFW area that I'm in right now, and so it'll probably go to 1 a week, maybe more. Anyway, some of the exclusive content is Arlington Private Information Share, which is 9 videos by itself. Land deed training, estoppel certificates training, foreclosure estoppel certificates training, corporate denial training, toll roads notice and demand training, invoice training, notice of void judgment training, revocation of signatures training, third-party witness training, federal habeas corpus training, revocation of voter registration training, and then there's criminal complaint training. There's a couple of those, and there's going to be more. Upcoming lawsuits, lawsuit training and other training will be some upcoming content that I'll be putting up. All forms, files, and other instructions are available for free on my 2 private groups at Yahoo Groups and Google Groups. The exclusive content will be available on my website, and it's really above and beyond, and you can buy a subscription there. All of the free videos are basically designed to tell you what's going on and how you can defeat it. All of that stuff is free. If you want training on how to do stuff, then that's above and beyond.
get a lot of this stuff. He's learning. He understands the conspiratorial stuff, but the other stuff about, he's still getting his head around it, you know. But I could tell you that he's got this house in Austin. It's like, I think he paid like $210,000 for it, when it's like, it's a crack house, right? I told him I would have never bought that. But he figures he can turn around, he can fix it up and double his money, you know. So anyway, so it's in a decent neighborhood for sure, and so he's fixing it up and he's doing it all himself, and he's pretty talented that way, and he just tells the city, get off my property.
Well, gotta be belligerent.
Yeah, you do.
Nice. So with utilities, how do you get around not having utilities?
Gotta figure out a way. But I'm saying
solar.
Well,
use solar electricity. There's lots of ways of doing it.
You gotta do. You can do septic. You can do water
You can have all the conveniences without having, you know, their power, and at the end of the day, you know, it might be even less expensive. There's actually guys on YouTube that have. There's this Kesh, guy by the name of Kesh. He's Iranian, but he's a nuclear physicist, and he's in England. He speaks English with an Iranian accent. But he's just got this device that works on plasma, that puts out, like, you can build this device. He tells you how to build it and everything, and it'll put out like 4,000 watts of energy, and so you can, 2 of them will power your house for you, you know, and you just build it and it runs by itself. You got to kickstart it, but then it'll run by itself.
There was a story of a kid in Africa who did that for his town. He learned about all of this stuff and built a power plant out of junk, and then they wanted to shut it down, but eventually, I don't know the full story. But
I've seen that YouTube or whatever.
A lot of people, they do get shut down and do that stuff, but this Kesh guy is he's a nuclear physicist, and he's had confrontations with them, and he deals with it, and he's made it available for free on YouTube.
I think he's making it to many nations for free, but not to the U.S. I think he was having a problem with Obama.
You know, I don't know. I saw it on YouTube during the Obama administration, and I started actually building one with some people, and just didn't get it finished.
And it's KESHE, isn't it?
Yeah.
There's another device that comes out of, I don't know, they're Romanian or whatever. And they took, they take a motor, they drive a generator with it, with a feedback loop to the generator, just get it spinning. You know, you get 5 kW easy. You know, you can build.
There's a lot of these devices out there.
Yeah, there is.
And you know, they're trying to suppress them, but I think that it's getting out of their control.
Yeah, just Google over Unity devices, you find it.
Anyways, recent land patents, like the Canadian one, are inside a box. Land is granted to John Smith, his heirs, and/or assigns forever. Okay, and there's no restrictions or anything like that, except that sometimes they reserve like mineral rights or trees or water rights or something. That one of those ones, the one in Texas, if you look at it, I think it has mineral rights reserved, but that's it. Okay, and they still have to get permission to come on your land. You know, even if they have mineral rights, they got to get permission to come on your land if they're going to come on the surface. You see what I'm saying? And so, you know, you just can't sell the mineral rights. That's all. And that's those are fairly recent. The older ones, there's no reservations at all. Like that Texas one, that Sharp Whitley land patent, there's no reservations in there, I don't believe. And so it's basically the government sold you the land, you paid for it with gold or silver, back then it was gold or silver, and you have absolute title. You're literally king on your piece of property, and based on the congressional record, that's exactly what they intended to happen. You see what I'm saying? They say nothing about property taxes, nothing about easements, nothing about eminent domain, nothing about zoning rules and regulations. Sometimes they reserve mineral rights. Other than mineral rights, there's no reservations. A usufruct. We're going to talk a little bit about trusts. A usufruct is the right of enjoying a thing, the property of which is vested in another, and to draw from the same all the profit, utility, and advantage which it may produce, without, provided it be without altering the substance of the thing. A usufruct is a type of a trust. Holy cow, it's 1 o'clock. We got to get moving. We've been getting distracted here. When you pay for land with a banknote, commercial paper, it's not paid for, therefore a trust is created. You got to think about that. That's what happens. Some guy promised to pay me. When he pays me, I'll pay you. Well, that creates a trust. Eminent domain. That's why the government has eminent domain. If, I guarantee you, have you ever seen, I've seen them, you ever seen a road that goes along in a straight line, and then all of a sudden it goes around this guy's land, and then it keeps going straight again? You ever seen that?
Yes.
Yeah.
No.
Well, that's because they didn't have colorable title on that land. That guy owned the land patent on that land, and they couldn't take it from him. They didn't have eminent domain. When you buy land with Federal Reserve notes, then you really don't own it. You know, and the government can take it, eminent domain. You see what I'm saying? But if you have absolute title on the land, they can't take it. Yeah, and that's what I talk about here.
My thought is that assuming you have a land patent and then one goes into some sort of commerce, does that then take you back into their powers?
I suppose that if you ran a gas station on your land, you know, or something like that, then it could, you know, I don't know.
Unless it's the difference like
But if
Dan
you
said, if it's just land versus buildings, that could give one, you could own the land.
Right, right.
And then whatever's happening above it could be commerce, but there's still no
Could.
attachment.
If you own the land outright, then I think it is still own the land patent. And if you own it, not some corporation, you see what I'm saying?
Yeah, the corporation.
And so then, like if I had a gas station, I'd be more inclined to, I'd set up some trusts, you know what I mean? And I'd have a trust own the gas station and lease it. You see what I'm saying? I'd have all sorts of stuff. There's a guy, the guys that showed me this talked about a swimming pool, because swimming pools expose you to a lot of liability. So they talked about how they knew people that the trust would own the house and the property, and then another trust would own the swimming pool. And if some neighbor's kid gets hurt in a swimming pool, and they get sued, well, there's a contract between the trust that owns the swimming pool and the trust that owns the house. And if there's 30 days notice and they got to get the pool off the property. You see what I'm saying? There's little things like that. You see what I'm saying? So if the trust that owns the pool gets sued, well, you give them the pool, and you got 30 days to get it off the property.
Oh, gosh.
So there's lots of little things like that. You see what I'm saying?
Yes, thank you.
Spanish land grants in Arizona. There's huge sections of land in Arizona that are part of Spanish land grants. That was before the United States was here. Yeah. That was before the war with Mexico. You see what I'm saying?
Still there.
They're still there.
Don't trespass.
That's right. That's right. That's right. I know people in Arizona that have had land for generations, and they do not pay property taxes and never have. I've heard of people in Canada, and the same thing applies in Canada. They make it a little bit more murky and hard to find, but I know people in Canada, there was people I've done private information shares up there, and they would say that it was basically friends of friends, but people that would have land, and they'd go to land titles, which is where the records would be for the land, and they couldn't find the title. Well, that means it's not there, right? Right?
Yeah.
Federal Reserve notes, Bank of Canada notes, Bank of England notes, or IOUs. See the Bankster Thieves 1, 2, and 3 videos. There's no such thing as a bank loan video. There's a distinction between a debt discharged and one paid. When discharged, the debt still exists, though divested of its character as a legal obligation during the operation of the discharge. These banksters lay awake at night with this stuff. Evidence of your usufruct, okay? They call it real estate. You pay a yearly rent in the form of property taxes. They can take it away from you, eminent domain. Your land has easements, utility roads, etc. Your land is subject to zoning rules and regulations. If you pay for land with an IOU, it creates a trust. The way you defeat the trust, you have to pay for the land with gold or silver coin, and you have to say it in the deed.
Can you pay in silver coins to corporation, or if it's an LLC?
Pay silver coins to a corporation?
Yeah.
You mean when you
Well,
buy
you could.
it? Why
Yes,
would you
yes,
want to?
yes.
If you're buying it from a corporation in
Yes.
the name of a living
As long
man.
as they'll accept it. As long as, what I'd want is the deed is worded properly. Usually, that's why I have it sent. If you notice on some of these ones, I had to deed it to, you know, a structure, and then I deeded it from the structure to me, because then I'd have controlling over the wording. I'd have control over what the wording was, and but there's if they'll, like one of these had where the people, it was in Las Vegas, and they were very interested in what I was doing, and they had no trouble at all making the deed say what I wanted it to say.
We talk of gold and silver. Is a post office money order, is that lawful money?
Well, they say it is, but I wouldn't use it. I wouldn't call it gold or silver.
Okay.
I would, again, you have to, it's still a type of commercial paper, right?
Okay.
I would
But I thought
still,
it was backed by,
it might be,
Yeah.
but I would still say gold and silver
right,
on the deed.
okay.
Okay, you don't want them presuming anything. You don't want to give them room
Right,
for any of their presumptions.
right.
The way I do it, because I buy it silver, is I put on the bill of sale. I always call it bill of sale. I never call it a deed.
Yeah,
And
I think
put
that's
on
a good
there
idea too.
For the value of silver. I don't put the amount of the value, because none of their business how much I paid for it. I put for the value of silver and other consideration. I don't say what the other consideration is. That's Federal Reserve notes. When I do the transfer, I hold up one coin. I say, this is what I'm buying your property with, and here's the other stuff you asked for.
There you go.
That's simple.
Nice.
That's simple.
So, I mean, I don't have all the answers. There's a lot of other people that have good ideas about how to do this too. Anyways, you can have true loyal title to land. You bring forward all the rights and privileges of the original land patent. You pay for your land with gold or silver coin, or at least show that it was paid for with it. At common law, all numbers are spelled out, okay? You never use a number 5. You always spell it out, F-I-V-E. Okay, that's how it's done. You look on these land patents, okay? There's no numbers on there except for the number of the patent, and that's it. Everything else is spelled out. The legal description should be in metes and bounds, but it's not fatal if it isn't. If it's, for example, Lot 1 in Rancho subdivision, you could say it's Lot 1, use a metes and bounds legal description, also known as Lot 1 in Rancho subdivision. You see what I'm saying? A patent from the original people would trump any other patent. I wonder if Trump would trump any other patent.
Well, he's got gold.
He's got gold, that's for sure. Yet, still it was difficult to set bounds to ecclesiastical ingenuity, for when they were driven out of all their former holds, they devised a new method of conveyance by which lands were granted. That's the Roman cult, folks. Not to themselves directly, but to nominal fiefs to the use of the religious houses, thus distinguishing between the possession and the use, the receiving the actual profits, while the season of the land remained in the nominal fief, was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks. That's quite the scam, eh? So they get you into a contract, and they get to decide whether there's a contract or not. to be bound in conscience to account to assist to use for the rents and emoluments of his estate. That's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. And that speaks volumes. Because almost everything is done these days with commercial paper, the courts presume that commercial paper was used unless you put something else down. You can defeat their presumption by putting in the land transfer document the type of payment that was received. A bill of exchange upon receipt of 20 each 1 troy ounce pieces of silver each. I do hereby grant in exchange to John Henry, House of Smith, this land, together with all the rights and privileges of the original land patent number 123456, a true copy of which is attached hereto, all of which is incorporated herein by reference in its entirety. It's that simple. When you get true allodial title, you do not tell them you purchased your land. That's another thing. You tell them you converted some silver or gold to land. Okay? I've seen court cases that talked about it that way. So you converted gold or silver to land. Something of value for something else of value. Conversion's common law. Some jurisdictions have a land transfer tax or an affidavit of property value. Arizona has an affidavit of property value. New York has a land transfer tax. That's perfect, because you serve on then your instrument by registered mail, and they'll return it to you saying it's not recorded, but it's in a special file. Well, that's the non-tax-paying file. Because the courts have ruled, and this is one way you can do it, the courts have ruled that once they got it, it's filed, regardless of whether they stamp it or not. Some counties require it to be a land title document before you can record it. It's easy to make any document a land title document by inserting at the top right corner of the front page the following information. Section, this is I shown you yesterday how I did that. And this works. Meets and bounds legal descriptions. Meridians are vertical lines on the earth that run from pole to pole. Ranges are horizontal lines that define the top and bottom of a township. And a township is 36 sections, so it's 6 miles by 6 miles. A section is 1 square miles, which is 640 acres, and 1 acre is 43,560 square feet. So in older parts of the country, the meets and bounds legal description run from landmarks, the old oak tree or where the rivers meet or something like that. But you get out west, and it's all by section, township, and range. Meets and bounds legal descriptions are common law. Every state has a base and meridian that all legal descriptions are taken from. Alberta uses the 4th meridian, which is the border on the east side. Utah uses the Salt Lake Basin meridian. Arizona uses the Gila and Salt River meridian. Your local city planning department will probably be able to tell you what section your land is in and the base and meridian it's taken from. An instrument is deemed in law filed at the time it's delivered to the clerk, regardless of whether the instrument is file marked. That's a Texas court case.
Same in New York?
Probably find some. You could use the Texas one, because there's a thing called the full faith and credit clause, where the stuff in Texas has to be recognized in New York, and New York has to recognize Texas, right?
Reciprocity.
Reciprocity, that's right. The King of England held ownership of land under a different title with far greater powers than any of his subjects. Though the people of England held fee simple titles to their land, the king actually owned all the land in England through his allodial title, and though all the land was in the feudal system, none of the fee simple titles were of equal weight and dignity of the king's title, and the land always remaining allodial in favor of the king.
Right.
So we're kings, right? We have all the rights of the king. I know people who have land patents on their land, and they pass it on to their family and done that for generations, and they do not pay property taxes on it and have never been contacted for any taxes. I currently own land that's not on any tax rolls. A lot of it depends on how corrupt the local government officials are. A lot of it depends on the people. You know, we the people need to hold their feet to the fire, and we need to start demanding, you know, that our property be taken off the tax rolls. Once we understand the nature of what's going on, you know, that's why I tell people about this. I cannot fight all the battles. We all need to just take up and take the ball and run with it. And you know, there's a story that I have about in Ontario, Canada. They had, and I know about this because I lived there for a while, they had photo radar for a period of time. But they canceled the program after about 3 months. Most people don't know why they canceled it.
They still had them when I left.
They what?
They still have them in 2015.
Maybe some parts of Ontario, but certainly they used to have it on like on the freeways and stuff like that. Where did they have it that you know about?
Cities.
In the cities?
Yeah.
In Toronto?
No, Kitchener.
Right, that's a long ways away from Toronto.
Yeah.
They used to have it in Toronto, and what happened was in a period of 3 months they got 250,000 court cases. And the courts can't handle that. It doesn't matter if you're on point or not. And so they canceled the program. So that's my point, is if enough people stand up, even if you're not on point, it doesn't matter.
Bury them in paper.
They get the message.
In Ohio, it was found unconstitutional.
Is that right?
They had to have a police officer standing on the corner.
It's got to be a witness.
Right.
So, yeah.
I've got a video about do-it-yourself photo radar. Okay? Thanks for sending your hearsay evidence. Do you have any witnesses to this alleged crime?
Yeah, can they appear in court?
Yeah. There's a guy that I know in Canada that what he did is he took a picture of him signing the check and he sent it to him, and he said, thanks for your hearsay evidence. Thanks for your image of me speeding. Here's an image of me signing the check.
Or just a photo of the check. No,
Well,
going to do that with a mortgage.
a lot of those photo tickets down at the bottom, it says cannot be used as evidence.
Well, there you go. So if it can't be used as evidence, then it means nothing.
You send a letter back saying strike the evidence. Strike the letter.
That's right. So
Your last line there, how are property taxes a denial of due process?
did you consent?
No.
Is there a contract?
No.
Well, that's a denial of due process by definition then, isn't it?
Their oath of office says, you know, the Constitution says no state shall make them into gold or silver payment for debt, and they're in violation every time.
If there's a contract, like a corporation has a contract, but a man or woman doesn't have a contract unless they get it in writing.
They said the deed is in Ohio. The deed is the contract. I asked
Oh,
for the
yeah.
jurisdiction.
They're right, it is.
The jurisdiction in the contract, and he said it's the deed and it's the form that you filled out that says real property conveyance.
Oh, so they give you a form.
Yeah.
Well, don't fill out the form.
Well, yeah, well, I asked him, that was obviously a mistake. How do I correct a mistake? And that's at the point that he says you'll have to deal with the prosecutor.
Right.
The other
They're
problem is
intimidating me, and so is the treasurer.
Right.
The other problem
Transfer the land.
Right.
Transfer the
I'm
land.
going to do that. I'm taking it out of the foundation, but the foundation is an unincorporated association. And the tax definition of person does not include an unincorporated charitable association.
So what's that got to do with anything?
It doesn't have to do with me because I'm not subject to the tax.
Right.
The foundation isn't, according to their verbiage.
And don't use any tenant.
There
Anything
isn't,
that they have with tenant on the deed, don't use that.
What I would do is I would just transfer the property, and I would, since they have a form to fill out, I'd serve it on them by registered mail, and when they send it back, that's great. That's done. It's on the non-taxpayer list now.
I'm going to do a bill of sale. I'm
Yeah,
going to buy
yeah.
it from the foundation.
Bill of sale.
Originally, the trust had gifted it to this charitable unincorporated association. We gifted it, so there was no exchange.
Yeah.
But I'm going to do it.
I like the bill of sale.
I am.
I like the bill of
Bill,
sale.
if you have any templates, I'd be interested.
I do.
Thanks.
Anyways,
I don't care what Glenn.
I helped a friend bring forward a land patent on his property in Kent County, Texas. The friend died, the Tarrant County thieves continued to try and steal his property. His family did not have any idea about land patents and had no interest in defending it. The Tarrant County thieves stole his property with a tax sale. The friend's neighbor bought the property in the tax sale. Another friend was talking to the neighbor about his purchase of the land. The neighbor said that because the land patent was brought forward that he could not get bank financing. And he had to get a friend to finance the mortgage. That's the power.
Yeah.
You have no idea the power of this. The banksters know what it is. They're not going to tell you. It's like the news media. They don't tell you the truth. They feed you lies and BS. The banksters are no different. They're part of the same system. Once you understand what's happening, this friend of mine that showed me this called it the quiet displacement of equity. Okay, equity being all of the stuff that's going on, and it's like oil and water. And when you do the right things, it's like oil and water, and it just goes away. The quiet displacement of equity.
So down the road, so the land patent was there. The family didn't have any interest in it, of defending it.
Yeah.
But it still exists. But then someone's putting a house on it.
Right.
So
Well,
down
no,
the road.
the property had a house on it.
Oh, we couldn't get the financing. Okay. So the
It's
land
worth
patent.
about
So
200.
really, the land patent, it's only the land. It's not what's on the land.
That's true.
So
The land patent's on the land.
So they could, whoever has the land patent could basically tell the house to get off the land.
If but they're idiots, and I doubt that they would, quite frankly, or have any clue about what it all means and everything.
So I'm just thinking down the road, at what point does the land patent lose its power, and whoever had it at the whoever it had been, could the current owner who now is on the property bring forth the land patent?
That's a good question. Now, think of it this way. You remember when you ever heard of homesteading? People would go out to these land.
160 acres.
Yeah. What was the deal? Remember what the deal was?
Prove it.
Huh?
Live there a certain amount of
5
time.
years
Right.
or something?
No, it was 7 years.
7 years.
They had to live on the land for 7 years. And after 7 years, the government would give them a patent.
Right.
So that's the key, right? 7 years, that's squatters' rights.
Right.
Oh.
Yeah, the adverse possession laws go with
Right.
7 years too.
Right.
Yeah.
Right. That's squatters'
Longer in
rights.
Ohio.
After 7 years, if you're living on the land, then it's yours. It's got to be, there's some criteria for that. Has to be notorious. In other words, in front of everybody. You see what I'm saying? That kind of thing.
Yes.
You see what I'm saying?
The squatter's right. Have you essentially established a land patent just by living there for 7+ years?
Yeah.
Yeah.
Yeah. That's why, remember the court case that said that there's a lot of things that constitute color of title? But really, just the fact that you're on the land is color of title
So
too.
the adverse possession is, say, state-oriented, but there's actually a higher action one could go for.
Right, and this lady that was in Texas that they'd been living in this house for 10 years without making a mortgage payment. And I told her, I says, you got squatters' rights. And that's really, it's adverse possession. She needs to bring an action, a quiet title action in the court for adverse possession. Because she hasn't made a mortgage payment for 10 years. So she's squatted right now. You see what I'm saying?
What about
She
when
can bring
it's-
forward the land patent and that helps, but really it's just squatters' rights. What?
I've been there 38 years. Now you say that gives me color of title. Well, I don't think we want color of things. We want a genuine thing like a land patent.
Well, the fact that you were on there, it's all color of title. Okay? Really. It's all color of title. Because who owns the land? I mean, I don't own the land.
That's a good
The
point.
universe owns the
That's
land.
true, that's true.
Okay?
And the Indians once did.
Whatever. That's right. Yeah. What were you going to say back there?
I haven't paid my mortgage almost 10 years. It's going to be 10 years in October. But Massachusetts adverse possession is 20 years. So
Really?
I'll probably have to wait 20 years then.
If that's the case for Massachusetts, then you're probably going to have to wait. I'm surprised it's so long.
Yeah, 20 years.
Yeah,
Wow.
is that statutory though, or common law?
Well, it would be statutory for sure.
Right.
But he's got to get the courts to enforce it, and they only deal with statutes. You see what I'm saying? So, unless you can convene a common law jury. And then the next question is what's the cloud on the title? Is it a mortgage?
Yeah, they have, well, there's a foreclosure deed now. They did a foreclosure deed back in 2011.
Right, so somebody's on it?
I'm on it. I'm there.
Oh, you're on it?
Yeah.
So there's a foreclosure from 2000, so you've been on it ever since then?
Yeah, and I haven't paid since 2008.
Good,
October
good,
2008.
good.
So what's happening now is I have an affidavit that's clouding the title. They're always trying to sell it on auction.com. It's probably on there right now, and nobody's bidding anymore. That last year, a few people went over the reserve, but I never heard from them.
Put a, I do a common law lien. I sent you a copy of common law lien. And what I would do is, you got to justify a common law lien. It's like a mechanic's lien, right? So, like I went and did a common law lien on this land that I had in Arizona when the banksters stole it. And I put a $50,000 common law lien for, because I cut some trees down, right? And a tree can easily cost, you know, $2,000, $3,000, $4,000.
Yeah, it's like a sweat equity lien.
Absolutely, yeah. So you just put it that you did. You see what I'm saying? Maintaining the place. You could actually, you know, what you could do is it. Do you own it or does the structure own it?
I own it.
You own it.
Yeah.
And so you could have
the straw man, whatever. But yeah.
You could have. What? You got kids?
Yeah.
How old are your kids?
10.
That young, eh?
Yeah.
Okay. So, but you could have your wife. Is it your name or your wife's name or both your name?
Just my name.
Get your wife to put a lien on it for maintenance.
Yeah, that's a good idea.
Okay, so, mowing the lawn.
Yeah. So what I've been doing recently is they want to settle. They want to settle, so I made them an offer, and they said it wasn't enough. Then I did a follow-up offer. They said it still wasn't enough, and their minimum bid is $87,500, and then it goes in 25,000 increment bids. So my bid was below the minimum bid. So now I'm working to doing an offer that's going to be close to the minimum bid and see what they do. But this is costing them money all the time.
Right, right.
Bid $1 silver.
Huh?
Bid $1 silver. That's more value than their Federal Reserve notes.
Absolutely. But they don't deal in that, you know that.
Okay, so
It's an offer.
keep moving. What is due process of law may be ascertained by an examination of those settled usages and modes and proceedings existing in the common and statute law of England before the immigration of our ancestors. The expressions due process of law and law of the land have the same meaning. The law intended by the Constitution is the common law that had come down to us from our forefathers as it existed and was understood and administered when that instrument was framed and adopted. It is manifest that it is not left to the legislative power to exact any process which might be devised. The due process article is a restraint on the legislative as well as on the executive and judicial powers of government, and cannot be so construed as to leave Congress free to make any process due process of law by its mere will. Bringing forward the land patent is always effective. Whether or not it will be recognized by local authorities depends on how corrupt they are. When you bring forward the land patent, you will not be able to get bank financing or title insurance. You can do it with a transfer of the land. You can also do it with a confirmatory instrument, and I'll send you that. Remind me, don't let me forget. Templates of both are found in the files directory of the Yahoo group. Okay, so templates of these deeds that I circulated around, they're found in the Yahoo directory, and also the confirmatory instrument.
So are you going to change to bill of sale now with?
I think I might. Yeah, the next one I do, I think I do a bill of sale.
So we'll
I like that.
Yeah.
Well, I don't have any land that I'm planning on acquiring anytime soon. I do have some land that I do want to actually, but I don't know when it's going to happen. I got to contact the trustee.
So we could just get a template of the bill of sale, you know, just for the process.
Yeah,
as
you
if,
could.
As if you were.
You could get him to send it to me, email it to me. I'll look it over. I'll offer my comments. Okay. Now, if you watch my exclusive videos, you guys know how to do track changes in Microsoft Word. Let me show you. Microsoft Word is pretty slick. I really like it. I learned this when I was doing aerospace engineering consulting, working on the F-35 Joint Strike Fighter. Oh, let's do something different here.
Yeah, I had a hell of a time trying to acquire nickel wire for the control stick on that.
Oh yeah, nickel wire?
Yeah.
Get that wire then.
I think it was the F-35, maybe it was the F-15. They used a special nickel alloy in the control stick to vary the resistance of the computer, and we couldn't find anybody that was making it.
Okay, this is just a standard Word document here. And so we'll turn on track changes. It's under review, right here, track changes. So now it's on. So what I'll do, you send it to me, I'll review it, I'll track changes, and I'll make changes. Okay, so if I make changes, I'll say, well, that's not Hannah, that's Joseph. Okay, you see what I'm saying? And this one is not an account. This is a contract. And you can actually circulate this document amongst a whole bunch of people, and it'll show who made what changes. You know, you move your mouse over top of this change, and see right there it comes up, and it says, user deleted Hannah, right? That's me, because I don't ever put my profile in there. And so I'm then isn't there as user, but if you, like in a big company like where I was doing the F-35 Joint Strike Fighter, we had all sorts of engineers and it was all logged into, so is this one would say John Smith did this one and Joe Blow did this other one and etc. Okay? So anyways, so you get these changes and so when you get them back, you look them over, you decide whether you can accept them or reject them, and you do a right click right there. Whoops, that's because it's got a, okay. Ignore. There we go. There we go. That's the menu that I wanted. Okay, and so I can accept or reject that change.
Or do a different change.
Or do a different change. Yep. I'll reject the change. Okay, so accept insertion. Accept deletion. Okay, so it's that simple. Then also, another thing you might see is I might decide to make a comment. So, are you sure you want to do this? So, and then all you do is you can either make another comment back at me, or you can just delete it. So it's pretty slick that way. And then you save it every time, and you have a complete record of all the changes that were made and who made comments about what, and for the records. You see what I'm saying? Now, not that I want to keep records or anything like that, but it's easy when you're shooting something back and forth. I can make changes.